morning, Your Honor. I'm Stephen Ross Johnson, counsel for Kenneth DeHart.
Your Honor, good morning. Robert Kurtz on behalf of Mr. DeHart. Yes, sir.
Morning, Your Honor. I'm Ryan Desmond. I'm the district attorney here for the 5th Judicial District of Tennessee.
All right. Thank you.
I'm Maria Cutchon with the Tennessee Bureau of Investigation, the investigating agency, I'm sorry.
Okay.
Good morning, Your Honor. Tracy Jenkins. I'm the Deputy DA.
Good morning, Your Honor. Tyler Parks, Assistant DA.
You did all the work here, I saw.
Not all over.
That's fair. No, that's fair.
Good morning, Your Honor. Tiffany Smith, Assistant District Attorney.
Good morning, Your Honor. Thomas Small, Assistant. All right. So we're here back at preliminary hearing stage, and we've got some motions filed by the defense. Two motions, one to suppress and one for bond. Correct?
That's correct, Your Honor.
That's it. That's it. That's all.
That's it. Those are the motions we filed.
And I got the responses from the state.
Thank you.
So, I suppose the suppression will take the longest. Be glad to start with that if you want to wait.
Whatever Your Honor would prefer.
We are.
Your Honor, for the state's purposes, the proof for the suppression motion on behalf of the state is going to mirror the proof from the probable cause. The same witness that would testify as to the suppression motions would likewise testify to the same factual scenario regarding the probable cause determination. I think it's within the discretion of the court how it would like to handle that, if it wants to hear the proof twice or if it just wants to hear the proof once. The state's preference obviously would be to just consolidate the probable cause and the suppression motion into the one hearing since it contains the same proof. But I believe that's within Your Honor's discretion.
Thank you, General Desmond. Yes, sir.
No, we agree. I mean, our preference would be, if it pleases the court, just to take all the proof and on the legal issues of probable cause and suppression at once.
As much as I like being here, I agree with you. Shorter is a little better. So,
Well, and I think to simplify matters somewhat, a portion of defense counsel's motion to suppress is relative to a statement the defendant gave after being taken into custody. The state is not proffering that statement. It is not offering that statement. So I believe for the purposes of that part of the motion to suppress, that's going to be moved at this particular hearing unless defense counsel, you have a different take.
I don't have a different take on that. I mean, a lot of the evidence that we were going to present and some of the witnesses that we had subpoenaed in today have to do with the circumstances of Mr. DeHart's arrest in Knox County, his transport over here to Blount County, and what occurred prior to this statement that was obtained by the TBI at the Blount County Sheriff's Office. If the state's not going to introduce it today and is not going to rely on that in support of probable cause, we agree that does move that issue.
okay, that's fine with me. I guess what I want to make sure, because I couldn't tell from your motion, you didn't really articulate what exactly you were trying to suppress. Are there other specific things that you're asking to suppress today?
Yes, Your Honor. What we're asking to suppress is, on the basis of our motion, we have moved to suppress all evidence from the traffic stop itself, and that is in its constituent parts. The first issue that we've raised is the length of the detention, and that the stop exceeded the scope of the basis for the initial investigatory stop of Mr. DeHart. And so we would argue that the length of the detention, it's a variance issue. Everything that flows from that seizure, all evidence in this case, not just physical evidence, but all evidence in the case. And the Fourth Amendment exclusionary rule is not limited just to physical evidence, but that all evidence following that should be suppressed. If the court determines that the length of that stop does not violate variance, does not violate the Fourth Amendment of the Tennessee Constitution, then separately we have raised the Fourth Amendment issue of excessive force. And excessive force is an unconstitutional seizure, and so when Mr. DeHart was tased repeatedly 4 times in succession in a parked vehicle for refusing to get out of the vehicle, we maintain, and we have briefed this for the court, that is excessive force. Excessive force is a violation of the prohibition against unconstitutional seizures in the Fourth Amendment and the Tennessee Constitution, and that all evidence from that excessive force forward should be suppressed. So it's not just tangible evidence, it's all evidence in the case. That's the basis of our motion.
No, I agree that that's the basis of his motion. I certainly have a different take on the analysis, but that is the basis, Your Honor.
That's just what I wanted to get from him, so I was looking for.
Yes, sir.
We'll combine this to probable cause and motion to suppress. There you go.
Thank you.
Thank you. Your Honor, before the state calls its first witness, relevant to both the matter of the felon in possession of firearm and ultimately the bond determination, the state would seek to introduce 5 certified copies of prior criminal convictions of Mr. DeHart, which it would like to make the first 5 exhibits of this hearing. The first, Your Honor, would be a Blount County Circuit Court case C-13894, wherein the defendant was convicted in 2003 for the charge of aggravated assault. The second, Your Honor, would again be a Blount County Circuit Court case C-15837, wherein the defendant was convicted of felony reckless endangerment with a weapon. And that was a date of offense of 2004 and a conviction date of 2006, Your Honor. Thirdly, Your Honor, is a conviction from the U.S. District Court in case number 304-CR-150002 for felon in possession of a firearm. That is an offense date of August of 2004 and a conviction date of September of 2005. Fourthly, Your Honor, is a conviction from Blount County Circuit Court in case C-25401. That is the charge of domestic assault with an offense date of June 2017 and a conviction date of August 2018. And finally, Your Honor, again out of Blount County Circuit Court in case C-25676, a conviction for a criminal violation of order of protection with an offense date of September 2017 and a conviction date of August 2018. Thank you. And with that, Your Honor, the state would call to the stand Deputy Shelby Edgars. Good morning. Would you state your name for the record, please?
Shelby Edgars, Code,
And where are you employed?
Blount County Sheriff's Office,
And how long have you been with the Blount County Sheriff's Office?
a little over 6 years.
What is your current position with the Blount County Sheriff's Office?
I'm a canine handler assigned to patrol.
And back in February of 2024, what was your position with the Sheriff's Office at that time?
I was a patrol deputy.
Deputy, can you just briefly talk about some of the training you've received in becoming a deputy in the Sheriff's Office?
Yes, so when I first started, I worked in adult corrections, so I went to the Corrections Academy. I worked in adult corrections for approximately 3.5 years before moving on to patrol, and then I went through the Tennessee Post Academy, be certified to be a patrol.
And when did you go through the Post Academy?
August of 2022 through November of 2022.
Okay. So you had been on patrol for approximately a year and a half as of February of 24, is that fair?
Yes.
Now, Deputy, just in generally, when you're on duty as a patrol deputy, what are your responsibilities while you're on a particular shift?
Patrolling the roadways, doing property checks, and then of course answering any calls for service. So domestics, welfare checks, somebody stuck on the side of the road, anything like that.
And you mentioned a shift. How are the shifts set up at the Blount County Sheriff's Office? How does that work?
We have first, second, and third shift. First shift is from 6 a.m. to 4 p.m. Second shift is 3 p.m. to 1 a.m. And third shift is 8 p.m. to 6 a.m.
And in February of 2024, what shift were you working at that time?
Second shift.
And that is the 3 p.m. to 1 a.m., is that what you said?
Yes.
Okay. And when you're on a shift, is the county broken up into different geographical areas? How do you determine where you're at?
Yeah, we have the north end and the south end, and then in each of the north end and the south end, we have two different zones. So in the south end, we have zones 1 and 2, and in the north end, we have zones 3 and 4.
And do you know which zone you were assigned to back on February the 8th, 2024?
Yes, I was assigned to County Zone 3.
Okay, and where is that? Where in the county is that?
Rockford, Eagleton, Seymour area.
And just in general, how many deputies are typically on a given shift?
Well, on this day, there were quite a few because it's Thursday. It's a training day, so everybody that's assigned to patrol will work, and then if they're assigned to special division, will be in training that day. So our minimum is 6 and 1, so 6 deputies, 1 supervisor. I'm not sure exactly how many we had this day, but it was more than that.
How are those 6 typically set up? Or I guess 7, if it's 6 and 1, how are those 7 typically set up?
So there'll be at least 1 county supervisor, and then we'll have 4 deputies, each one assigned to all 4 zones, and then a backup north and a backup south.
Okay. And you had a backup on that day?
Yes.
Who was your backup on February 8th, 2024?
I cannot remember who the backup north was, but we had 2 county backups that day, and they were Deputy Reagan Powell and Deputy Noah.
And just in general, what are the parameters or situations you might encounter where you would call in backup on a particular occasion?
Really, any call that we go to, if you're in a backup role, you just automatically respond to whoever you're close to, the zone partner. We just try to back each other up when we're on anything.
If I could please direct your attention to February the 8th, 2024. Were you on duty on that day?
Yes,
And did you have reason to come into contact with the defendant in this matter on that day?
yes,
Is that person seated in the courtroom?
yes.
Can you please identify him?
Yes, sir.
And what is his name?
Kenneth Wayne.
Your Honor, I'd ask that the record reflects you identified the defendant.
All right.
Can you explain to the court how you came into contact with the defendant, Mr. DeHart?
Yes, I was traveling towards town on Sevierville Road, and he was in a vehicle in front of me.
Okay. And where on Sevierville Road were you?
First got behind him, Sevierville, close to Keeble Road.
And is that located in Blount County, Tennessee?
It is.
And did you ultimately conduct a traffic stop on the defendant on that day?
Yes, I did.
Can you explain to the court why you conducted the traffic stop?
The defendant failed to maintain his lane.
All right. More particular, what is it that first drew your attention to the defendant's vehicle?
Well, he first started by kind of going back and forth inside his lane, not crossing either line, but kind of swaying back and forth. He ended up, before I stopped him, crossing left of the double yellow line on the center, approximately 6 times.
Approximately 6 times?
Yes.
Okay. Now, your cruiser, was it equipped with a dash cam? What would we refer to the dash cam at that day?
Yes,
And did it capture the activity that you're referencing here?
yes.
About how long were you behind the defendant's vehicle? What kind of vehicle did you say it was?
It was a silver Lexus SUV.
About how long were you behind the vehicle before you activated the blue lights?
Maybe 2 minutes.
Okay. And where did you activate the blue lights at? Do you know where you were at that time?
The 4900 block of Sevierville Road.
Is that still located in Blount County, Tennessee?
Yes.
What did the vehicle do once you activated the blue lights?
After about 30 seconds, he came to a stop in his lane of Sevierville Road.
I'm sorry, in the what?
In his lane of Sevierville Road.
Okay, so he is in the roadway.
Yes.
Is that ideal?
No,
Why is that not
it's
ideal?
not safe for me or the driver.
Okay. So what did you do once the Lexus came to a stop on Sevierville Road?
I approached the driver's side window, and the defendant rolled his window partially down, and I just asked him to move up in the driveway that was in front of the vehicle.
Okay. And did he respond to your request?
Yes, he pulled down into the grass on the side of the road and then pulled horizontally across the driveway. However, my control car was still in the road. I didn't have room to pull up behind him.
So he pulled into the driveway, but basically not far enough to where your vehicle was still in the road. So what did you do at that point in time?
I reapproached the explained it a little differently. I asked him to turn his vehicle into the driveway as if he lived there and was going home to park and go inside the house, and he did so.
Now, did you reapproach the vehicle now for a little bit of a longer interaction?
Yes,
And who was operating that motor vehicle?
the defendant.
Okay, was anyone else in the vehicle?
No,
Okay, a couple questions. Had you ever met Kenneth DeHart prior to this night?
no,
Did you have any knowledge of him whatsoever?
no,
Did you have any history about whether or not he even had prior interaction with law enforcement?
no.
Prior to approaching the vehicle after the vehicle came to a stop, could you tell who was operating that vehicle prior to the stop?
No.
Could you see inside the Lexus's windows?
There were two.
Okay, so upon approaching Mr. DeHart, now that he's in the driveway, what's your initial interaction with him when you conduct a traffic stop and there's a driver? What are you going to do typically?
I introduced myself, told him who I worked for, and I told him the reason for my stop.
All right, and how did you do that in this occasion?
Yes,
And how did he respond when you told him the reason for the stop?
he said that he was sorry, that he was putting his hair up, and was telling me that he had just, I believe, left his son's game and got him.
Okay. Now, when you conduct a traffic stop, are you typically going to request any sort of documentation from the driver of the vehicle?
Yes, driver's license, registration, and insurance.
And did you do that in this particular case?
I did.
Was the defendant able to provide you with a valid, or with a driver's license?
Yes.
Okay. Did he do so quickly, or was there anything different about his providing that license?
He seemed to be a little bit distracted when I asked for him to provide me with those documents. It took him a few minutes to retrieve his wallet and get his driver's license out. He would stop doing that, pick up his phone, show me something on his phone, tell me about something that was going on in his life, things of that nature.
But he did ultimately give you a driver's license.
Yes,
And what about a registration?
yes.
And how about proof of insurance?
He could not find the proof of insurance at the time.
Okay. So based on that, what did you tell him was going to occur at that point in time?
I asked him to continue to look for the proof of insurance, and I was going to go check and make sure that all of his documents were valid.
All right. Now, while you're at this initial approach, prior to returning to your cruiser, do you detect anything that raises concern?
I noticed the odor of marijuana.
All right. And I guess, is there any particular way you would describe the odor of marijuana?
I would say sort of smells like a skunk, but maybe less chemical.
Is that something you've encountered previously in your
Yes.
employment?
Yes.
And that occurred prior to returning to your cruiser?
Yes.
All right. So you returned to your cruiser now. Let me ask you this again, prior to returning to your cruiser. I know you briefly described sort of what you observed the defendant. Just in general, how would you describe the defendant's demeanor during this initial interaction?
He seemed to be nervous about something, so I continually tried to dispel his nervousness and be friendly with him, you know, let him know that I'm just doing my job, just need to check everything out and make sure that you're okay to drive, and hopefully we'll be able to get you in point.
Did you ask him anything, if he had consumed any substances or anything of that nature?
Yes, I asked him if he'd had anything to drink or had any drugs or anything, and he said that he hadn't.
Now, why did you ask him that question?
Due to his driving behavior and his behavior while he was talking to me.
Now, did you ultimately return to your cruiser?
Yes.
What did you do when you returned to your cruiser?
I ran his driver's license. It automatically runs a NCIC check when we run the way that we run the driver's license. So he came back clear in NCIC. His license was valid, and I asked my dispatch to check him out of Knox and Superior County.
All right. And did anything come back?
No, it was clear.
Did you communicate with anyone while you were back at your cruiser at this time?
Yes, I did.
And who was that?
I had previously communicated over the radio while I was interacting with Mr. DeHart with Deputy Reagan Fallon. He asked me my status, and I told him, or I think he asked me my status and if I needed another. And I said, code 4, you can come on, letting him know that I'm okay, but, you know, you can come on back in.
And that was on the radio.
That was on the radio.
Was
So
there additional communication that occurred between you and Deputy McCowan, not on the radio?
Yeah, when I got back to my car, I called him just to give him a little bit more detail about what went on and what I was going to need from him when he got there.
What was your
investigate further on the odor of marijuana and whether or not he was impaired and could operate a motor vehicle safely.
Okay, so it was your intent to remove him from the vehicle for two different purposes, and those purposes, let's do them one at a time.
Okay.
What was the one purpose?
To investigate and make sure that he could safely operate a motor vehicle.
Okay, and how were you going to further that investigation?
I was gonna continue to talk to him and possibly do SFSTs, I'm so sorry.
And does that stand for standardized field sobriety test?
Yes, it does,
Okay. And the second reason you were gonna ask him to step out of the vehicle was what?
because of the odor of marijuana and his overall behavior. I was gonna ensure that there wasn't anything illegal in the vehicle.
You were gonna search the vehicle?
Yes.
Okay. Without telling what Deputy McCowan said, did you get indication he was going to respond to the scene?
Yes.
Okay. Did you eventually reapproach the vehicle of Mr. DeHart?
I did.
Okay. Do you know approximately, obviously the video will show us about how long it was before you reapproached the defendant's vehicle?
Maybe 3 to 4 minutes.
Okay. And when you approached the vehicle this second time, how did you approach it?
I made a passenger side approach, so I walked up on the passenger side of the car.
Any particular reason you did this?
It's just an officer safety tactic.
All right. Did you have further communication with the defendant at this point in time?
Yes.
And can you just tell us about that communication? What did y'all talk about?
He was on the phone with his grandmother, I believe, so I actually talked to her on the phone. And he was still trying to find valid proof of insurance. He handed me, I think, 7 to 8 insurance cards, which none of them were in date, but I looked for them. And then I told him, obviously I see that you had valid insurance on the car. That's not my biggest concern. My biggest concern is that, your vehicle smells like marijuana. I need to get you out and I need to check the vehicle.
Okay. Now, did he ever provide you with to your knowledge, a valid insurance card?
No.
Okay. How did the defendant react when you told him that you were going to ask him to step out of the vehicle?
He told me that he did not have anything in the car, that he did not smoke marijuana, didn't know anybody that smoked marijuana, there would be no marijuana in the car. And then he eventually refused, told me that he was going to refuse to search.
Did you have any conversation with him about, whether or not, in your mind, he could refuse a search?
Yes, I just explained to him that, based off my training, that the odor of marijuana and everything that was going on, I had to get him to step out of the car so we could search the vehicle.
All right. And how did he respond when you reiterated this to him?
He continued to refuse.
How long do you think this portion of the conversation went on between you and the defendant regarding you asking him to step out of the vehicle?
Maybe 5 to 7 minutes.
Okay. Eventually,
Excuse me, this is 5 to 7 minutes after you read the 4 that you read the patrol card, and come back the second time, you're there for 5 to 7 minutes. Trying to get to exit.
Yes.
One other question, I just don't know this. So when you got back on your radio, and you said you called to see, I assume you were checking was there any outstanding warrants?
Yes.
Okay. I assume, though, your computer is not able to pull up some driver's past criminal history?
Correct. It'll only,
It doesn't do that.
right, it'll only pull up, like their NCIC history, their driving history. If they have any warrants that are entered into NCIC, but they're not always entered in, especially with other agencies. And it pulls up their past criminal history in Blount County, but not in other counties.
Okay. I thought some of the exhibits were out of Blount County of this past criminal history. Did it pull those up?
It pulled, yes, it pulled up his local history, I'm sorry.
Oh, it did?
Yes, I made a misinterpretation.
Go ahead, Jim.
so you were able to see that he didn't have active warrants, but he had prior criminal history
Yes.
from Blount County. Is that accurate?
Yes.
Okay. While you're having this conversation with the defendant regarding him exiting the vehicle, eventually does Deputy McCowan arrive on scene?
Yes.
And where does he pull when he gets there?
He's coming from town on Seville Road, so he comes like to the driver's side, to the left side of my vehicle, or the driver's side of Mr. Wheeler's vehicle, and approaches the driver's side of Mr. Wheeler's.
And what conversation do you engage in with the defendant at that point in time, once Deputy McCowan arrives?
I tell him that, I can't, essentially I can't continue to negotiate with him, that he's gonna either have to step out of the car or he's gonna be forcibly removed from the car.
Do you know approximately, prior to things kind of getting physical, how many times you all asked, Mr. DeHart to step out of the vehicle or told him to step out of the vehicle?
Probably more than 20.
Ultimately, eventually was the decision made to remove Mr. DeHart from the vehicle.
Yes.
Okay, can you describe to the court how that went down, how that occurred?
I told him again, you're gonna have to get out of the car, I'm gonna have to forcibly remove you and you'll be placed under arrest. And he continued to refuse. So I opened the door, leaned into the car, tried to unbuckle him and get him out, and at that point he actively resisted against me.
Okay, and what did he do to actively resist?
We kind of, I guess a tussle would be the best way to describe it. I was reaching across and trying to get his seatbelt, and he was hitting my arms, hitting my neck, stuff like that. And I was trying to push him back to get the seatbelt unbuckled. Ultimately, he was overpowering me, so I decided to take a step back and take a different approach.
All right, so fair to say you were unsuccessful in physically removing him from the vehicle?
Yes.
All right. After your unsuccessful attempt to remove him, what occurred next?
I backed off. Deputy McCowan had drawn his taser, and he continued to give we both continued to give Mr. DeHart commands. I warned him, and Deputy McCowan warned him that he would be tased if he didn't get out of the vehicle, and he was subsequently tased.
Was he given the opportunity to get out of the vehicle prior to being tased?
Yes.
All right. Describe to the court the first attempt at a taser deployment.
So at the time we carried the Taser 7, and it has two sets of probes that are fired. The first set of probes that were fired, Mr. DeHart was able to pull one of the probes out, so there wasn't a successful connection. So Deputy McCowan fired his second set of probes, and that set of probes initiated correctly, and he was able to use the Taser.
Once there was a successful contact with a taser, what did you do to attempt to extricate the defendant from the vehicle?
So the first successful contact with the Taser, I moved around to the driver's door. Once it was over, I told the defendant he needed to step out or he'd be tased again. He still refused, so Deputy McCowan tased him again, and I attempted to get inside the car and reach over to unbuckle the seatbelt to pull him out while he was being tased.
And what occurred when you reached in while he was being actively tased?
The probes have wires on them that connect them to the Taser, and my arm got tangled up in the wires, so I was being tased as well, so I wasn't able to get him unbuckled.
Okay, so in addition, I guess you're getting tased at the same time Mr. DeHart is?
Yes.
All right. Once that occurred, what did you do?
I took a step back, moved back behind the B-pillar in order to figure out what our next step was, because obviously I couldn't reach in to get him unbuckled. And Mr. DeHart pulled out a gun and shot Deputy McCowan.
Okay. Did you actually see the gun?
No.
Okay. Describe how you sensed or you knew the shooting had occurred.
Deputy McCowan and I, neither one had our guns pulled out, and the gunshot, I heard a gunshot and it came from inside the car, right next to me.
And were you hit?
Yes,
And where were you hit?
my right leg, just above my knee.
And do you know if Deputy McCowan was hit?
I did not at the time, but yes, he was.
Did you observe where Deputy McCowan was after you heard the gunshots?
Yes, he was laying, kind of on the A-pillar, the driver's side A-pillar,
All right.
on his back.
What did you do after the shooting from the defendant's vehicle?
So it knocked me off my feet and kind of spun me around, so I was laying on my stomach on the grass with my back facing the defendant. I don't really remember how I got up. I somehow got up and ran behind Deputy McCowan's vehicle for cover in order to return fire. When I got behind Deputy McCowan's vehicle and pulled my gun out, the silver Lexus was still stationary. I didn't know what was going on, but I couldn't fire at the Lexus because there was a house directly in front of it, and there were lights on. I assumed that somebody was home. I didn't want to fire in that direction, and someone else would hurt. So all this happened in kind of split seconds. Mr. DeHart turned the car around, he drove around the tree and drove up to the yard. And as he drove up the yard back towards the Seville Road, I pulled my gun out and I fired 3 rounds in his direction.
Do you know if you struck the vehicle?
I believe I struck the vehicle in the windshield and maybe the driver's side mirror.
Where did the vehicle go as it passed you?
It drove back up on the Silver River Road and took a right and continued on the Silver River Road back towards town.
After the vehicle left the scene, what did you do?
Well, I had to fix whatever was wrong with me and try to apply to Deputy McCowan. So I applied a tourniquet to my leg. I didn't know where exactly my leg I was hit. I just felt pain kind of in my whole leg. So I applied a tourniquet just to make sure that I didn't have the femoral artery hit. And I had a bystander actually help me with that. And another bystander went to check on Deputy McCowan. I attempted to get Deputy McCowan to administer aid and couldn't walk.
Did you relay what had occurred over the radio?
Yes,
And ultimately, did other law enforcement respond?
yes.
And where did you go once other law enforcement responded?
The deputy helped me into the back of his car and took me to UT Medical Center.
Now, we've talked about your dash cam on your cruiser. Was there another device you were equipped with that would audio, video record the events of that evening?
My body went through.
Okay. So you were wearing a body cam. And have you reviewed that video?
Yes,
And did it fairly and accurately capture the events that occurred that night between you and Mr. DeHart?
yes,
Likewise, do you know if Deputy McCowan was equipped with a body cam video?
yes,
And have you reviewed that video?
yes,
And does it likewise accurately capture the events that you observed and witnessed that night?
yes,
And do you know if Deputy McCowan's cruiser was likewise equipped with a dash camera?
yes,
And have you reviewed the footage from that camera?
yes,
And does that footage capture the events that you witnessed that night and accurately depict those events?
yes.
Mayor, at this time, I'm going to ask to enter and play the dash cameras and the body cameras from the events that evening.
All right. Just kind of let us know which ones they are.
Sure, it's on the seat, it's on the screen, Your Honor. It's listed what you're watching. And if there's any questions or anything like that, I'm happy to pause or go back or anything like that.
And just for clarification, for the record, are these going to be partials from each camera, or are they going to be the entirety of the interaction with Mr. DeHart?
So it is what you have listed in your discovery as DA presentation. It's the same video we played at the first preliminary hearing. It starts with Deputy Edgars' dash cam up until the traffic stop. Once the traffic stop occurs and she exits the vehicle, it goes to Deputy Edgars' body-worn camera and plays throughout the duration of the event. It then goes to Deputy McCowan's body-worn camera from when he responds all through the duration of the event. And then finally to Deputy McCowan's dash camera, which captures the events from the cruiser itself. There is not, for instance, Deputy McCowan's body camera has 2.5 hours where after they've responded, I've not included that part in it, but it does play throughout the entirety of the events for which the defendant is charged.
Thank you. I just want to know what
Sure.
portions are going to be played. Thank you.
Wait, it kind of depends on what access we have.
Severe
cars on the roadway. Do me a favor, bro. Pull into the ground, that way we're all the way out of the road, okay? We're 35, way pulling into 49, 59. Now, sorry, sure, where are you? 4951, I'm right here next to Destiny Lane. Destiny, a little bit better. Are you this side of 13 or is that side? What side are you on? I'm on the other side. I'm on the hospital. I'm up here, past out from the Camden Rock towards out of town, towards Burnt Station. Okay. If you pass Alfred, come on past Alfred McCann, you'll see the lights. Okay, I'm going to. All right, thanks, brother. I appreciate it. You will. Thanks. 335. I have another call. Will you check Nelson's here, please? Did you figure the paperwork out, bud? Oh, okay. You got the card there? A bunch of them? Okay. I got you.
nice to hear you. I'd say nice to meet you, but we're not next to each other.
She says she works for Blount County, well, I'm not from Blount County.
Yeah, I don't think I do, man.
She works, works for,
Okay, I got you. I understand. We're all right here next to each other. I get it.
like, I don't know, girl.
But yeah, just all of us. Okay. Well, I'll sit there and see if any of them about it. I'm gonna leave this half with you. I'll take this one. Yeah, that's okay. I understand. It happens.
But long as you run a tag and stuff, it should show up, right?
It doesn't come back with the tag. No, a lot of times it will come back with the tag. It didn't come back with the tag. That's the only reason I'm asking you for it. There's that half. There's the old ones.
What you say, Mama? The insurance, it's okay. I don't know. I just put my hair up and she said I swear, so that's alright.
Here you go. See this. See what we can figure out.
She said you probably tired. I'm tired. Brush my hair and everything.
Yeah. How many kids you got, bro?
5.
5.
Yeah.
That's too many.
And I just left my 15-year-old game and he wanted to stay and watch the varsity.
Yeah.
And he had surgery in the morning. I just had surgery on my knee.
Oh, goodness. Well, that's not good.
I just literally just called him out to tell her that
Yeah.
I'm not going to be able to bring her clothes because I bring them in the morning.
I got you.
I don't know. I guess I can just handle all this stuff.
That's okay. I'm not too worried about it. I got you. You got like 15 insurance cards.
Yeah,
So
I'm
you're
really
good.
perfectly fine though. I'm really just going home.
Okay.
I'm going home and take a shower and lay down. I'm not doing nothing wrong.
I got you. Well, I'm gonna tell you this. I am gonna have you step out, hang out with me.
Step out for what?
So I smoke weed in the car. Have you ever smoked weed in this car?
I don't smoke it.
Okay, you don't smoke nothing?
No.
Yeah, has anybody ever smoked in the car?
Nobody. This is my mom's car.
Okay. I got you.
Man.
Okay. Well, let's smell it. So what I'm gonna do is I'm gonna have you step out and hang out with me. Okay. Our partner's gonna get here. We'll search as long as everything's good. I'll get you home.
Okay. Don't be like that now.
Okay. Don't be like what?
She trying to say she smells weed, and I'm like, you know I don't smoke weed. Nobody else don't smoke weed.
Okay. I didn't accuse you of smoking weed.
She's backpacks and smoke. We literally just
Okay.
Exactly. It's being a leather.
Okay.
Like this just gets me, man. My own flag, and they just being messy.
And they got nothing to do with that, bro.
I guarantee you what a dog right here for the dog on the store.
Okay.
So I'm gonna sit right here.
Our dogs don't hit on weed, and there's not a dog coming out here. It's me and my partner.
Well, I'm refusing to
No, there's no refusing. So when I smell the odor of marijuana, I have probable cause to search the
Yeah,
vehicle.
I need to get a dog, man. I'm refusing to search.
There's no refusing.
There's no weed. Go get your partner and tell him to come over and sniff.
Okay. My partner is not a dog. My partner's a person.
Okay,
That's
so
not a dog.
I come sniff. I'm
Okay,
refusing to search.
that's fine. You can't refuse to search.
Why can I refuse to search?
Because I've got probable cause to search the vehicle because of the smell.
Nobody ain't trying to be messy for no reason.
I'm not trying to be messy with you, brother. I'm trying to make this easy. Okay?
I'm just refusing to search. I love you, Mama. Yes, ma'am. I don't know why they're doing this, man. I'm just trying to go home. I literally just left your house. I literally just took a video so I could show you everything that everybody did with the paint and everything in the toilets, and they just pulled me over for no reason. They see my fucking hair put up. I'm black with dreads, and they pulling this mess for no
It ain't got nothing to do with that, brother. I didn't see when I pulled you over.
Nobody smokes weed. I don't smoke weed.
Okay,
I've never been around weed.
Okay.
That's
I didn't say you did. I didn't say that you smoked weed. I said it smells like weed in here. I didn't say you did.
Dog. I know you.
Okay. Go ahead and step out for me, Kenny.
I'm not stepping out. I'm refusing to search.
Okay, you're refusing to step out of the vehicle?
I'm refusing to search.
Okay, so step out of the vehicle. Step out of the vehicle. Come back here and stand with me.
I'm not.
3:35. I don't know if he's gonna get up for.
I'm
Just
just
step
get
out.
out. Just get out.
I don't have a dog. I don't have a dog to get.
directing me to get out the car. I'm not getting out the car.
Kenny, just get out the car, man. I'm not trying to make this difficult.
You are making it difficult.
I'm not making it difficult. I'm not being racist. I'm asking you, I don't have a dog,
Some of
sir.
these folks I don't smoke weed.
Okay, I didn't say you smoked weed.
I don't smoke weed.
Kenny, I never accused you of smoking weed.
You said I gotta get out this car. I'm not. I'm
Yeah.
refusing.
Yeah, I am saying you have to get out of the car.
I'm refusing it.
You can't refuse to search. I have probable cause to search
You gotta
you.
have a dog. You can't just
No.
say you smell weed.
Yeah, that's how the law works, Kenny.
No, it don't.
That's how the law works, brother.
I'm down here on some River Road, baby. Like, this is not right, man. I'm really not doing nothing wrong on any.
You're on the wrong side of the road, brother.
Baby.
You're on the wrong side of the road. That's why I stopped you.
Literally, I ain't doing nothing wrong.
Kenny, man, I just need you to get out of the car,
I'm
brother.
not getting out. I'm not getting out the car.
All you have to do is step out and say that. I don't have a dog to get,
You
brother.
could have just gave me a ticket and said, get on. I don't smoke weed.
I don't have a dog to get here, okay? I don't have a dog to search your car. I do not have a dog. I can't help you there. You know, I'd love to have a dog. I don't have a dog.
Down here, baby. I'm on some River Road, baby. Just go down some River Road like 10 minutes.
I just need you to step out the car, Kenny.
I'm refusing, sir.
Okay, so here's what's gonna happen if you don't step out of the car. We're gonna have to drag you out of the car, and then you're gonna go to jail. So you can either step out of the car, or I can pull you out of the car. You can step out of the car, or I'm pulling you out of the car, Kenny.
She asked you to get out of the car.
Get out of the car, brother.
I said, it's not like weed. I need you to get a dog, please.
No, we don't have a dog.
Get a dog.
That smells like weed, brother. Get out of the car.
Marijuana in this
Okay.
car.
I'm gonna tell you one more time, Kenny. Get out of the car.
I can't, man.
You
I'm
can't?
recording this.
Okay,
I'm
you can
telling you
record.
right now.
That's fine. I'm recording too. I recorded this whole interaction. Go ahead and get out of
I'm not doing
my.
nothing wrong.
You were on the wrong side of the road,
I
Kenny.
was not on the wrong side
You
of
were
the
on the
road.
wrong side of the road, brother. Get out of the car.
Side of the road.
Get out of the car. Get out of the car.
I'm not. No, you can't do that. You can't do that. You can't do this, man. You can't do this. Get your hands off of me, man. Please get your hands off of me, please. Please. Get out of the car. I'm asking you, please.
Get out of the car.
I'm
Now.
not doing nothing wrong. I'm doing the car.
Now.
Please, I'm not doing nothing wrong. Get out of the car. Please, can I get some
No,
help?
get out of the car.
Now.
Out of the car.
I'm not doing nothing wrong. Get out of the car. Why y'all doing this to me, man? Why you doing this to me? Get out of the car, man. I'm not doing nothing
Get out of the car,
wrong.
Kenny.
This is not my car. I'm not doing
I
nothing
didn't say it
wrong.
was your car. Get out of the car, Kenny. Go ahead, get it.
Out of the car. Get out of the car. There's your phone.
There's your phone.
Get out of the car.
I can't run away. Give me my cover. Give me my knife. You need to sit down. I need to get, you need to sit down. You need to sit down. You need to sit down. 335 is
She knows 11 blue orange five like this.
what's your name, brother?
Ricky.
Hold my hand, please. 335. Got time to get applied, 344's down. I can't get to him. He's not.
You're not ready?
Oh, I'm sorry, I'm not peeing. I'm gonna go back up. It's not your other places in the leg. That's all I feel. I didn't even think about comfort. Three oh six, how far out are you? I hear something, I think.
I hear.
335, I think I'm about to go unconscious. 344's down, I can't get to. I'm right here, I'm okay. I'm okay, take your grip, take your grip, God. Take your grip. I can't, brother, I can't. In your car?
Yeah, my car.
If you want me.
You got a sign on? Alright, where are you signing?
I think that's around me. It's around me. Right here.
I don't smoke marijuana.
You can either step out of the car or I'm
Can you please?
You can step out the car.
No, sir.
You will get out of the car.
It's racism, man.
This man says, I don't care what governor you're gonna do. She gave you a lawful command.
I don't smoke marijuana.
She asked you, she asked you to get out of the car.
You're out of the car.
I said it smells like weed. I need you to get a dog, please.
No, we don't have to have it all.
Get a dog.
It smells
There
like
has
weed,
been
brother.
no
Get out of the car.
marijuana in this
Okay.
car.
I'm gonna tell you one more time, can you get out of the car?
I can't, ma'am.
You
I'm
can't?
recording this.
Okay,
I'm
you can
telling you
record
right
it.
now.
That's fine, I'm recording too, I recorded this whole interaction. Go ahead and get
No,
out.
I'm not doing nothing wrong.
You were on the wrong side of the road,
I
Kenny.
was not on the wrong side of
You
the
were on the
road.
wrong side of the road,
I'm
brother.
on
Get
the
out of the
wrong
car.
side of the road.
Get out of the car. Get out of the car.
I'm not, no.
You're not going to jail for refusing.
No, you can't do that.
You're not going to.
You can't do this, man. You can't do this. Get your hands off of me, man. Please. Please get your hands off of me, please. Please.
Get out of the car. Get your ass out of the car.
Out of the car.
I'm not doing nothing wrong.
Out of the car.
Now,
Please, I'm not doing nothing wrong.
Get out of the car.
Please, don't ask me.
No.
no, get out of the car.
Now.
Out of the car.
I'm not doing nothing wrong.
Get out of the
Why
car.
y'all doing this to me, man? Why you doing this to me?
Get out of the car, man.
I'm not doing nothing
Get out of the car,
wrong.
Kenny.
This is not my car. I'm not doing
I
nothing
didn't say it
wrong.
was your car. Get out of the car, Kenny. Go ahead, Diddy. Out of the car.
Get out of the car. Taser report. Out of the car. Get out
Get that vehicle description out on channel 2. Yes, sir. Where are they out at? 2951 Cereal. 3907. Anyone else came forward?
body we see lying in front of that dash cam out there, who was that individual?
Deputy Gordon McCown,
And do you know if Deputy McCown survived this incident?
did not,
Did you attend his funeral?
did,
Where were you struck, Deputy?
my right leg,
And when you were transported from the scene here, where did you ultimately end up?
Newton Medical Center,
And what injuries did you determine that you had once you arrived at the Medical Center?
didn't have any broken bones or anything, just basically flesh wounds, so I had to wait on most of it. And I ended up having to have some scar tissue removed, beginning of this year.
Okay. How many, just one entrance wound?
One entrance wound and two exit wounds.
How long were you in rehabilitation of some sort or another?
Altogether, 6 to 9 months, you added in.
Did you go through any mock cross-examination?
Yes.
What materials did you review in preparation for those sessions?
I reviewed all four, camera videos, so both body-worn camera and both dash cam videos, and both of my TBI interviews, so one from the hospital and the one from one of our interviews.
Now, those TBI interviews, there are audio recordings of those interviews, correct?
Yes,
And there are also reports that were generated by the TBI.
I believe so.
Did you listen to the audio of those
I did.
interviews? You did? Did you review the reports prepared by the TBI agents?
I did not.
Did you review the Blount County Sheriff's Office use of force policy prior to
Did.
testifying? You did?
I did, yes.
Do you recall that that use of force policy says deputies are authorized to use only the amount of force necessary to accomplish lawful objectives?
Your Honor, I'm respectfully going to object at this time. I'm not sure how this goes to rebut probable cause as to the facts to establish probable cause. The facts are what they are. The facts are in evidence. I'm not sure how the sheriff's office use of force policy could possibly rebut probable cause in this particular case. So respectfully, I'm going to object to that line of question.
All right, of course, remember, we were trying two things at one time.
Yes.
I mean, this goes directly to the suppression issue, Judge.
I agree with you on that point. I agree with you on your point, so objection overruled.
Thank you, Judge.
Thank you.
And Judge, I'm bringing this up now because I'm just going through what you reviewed prior to doing it. And so prior to your preparation, for your preparation today, you did review the use of force policy,
Yes.
correct? I'd like to mark this for identification at this time as whatever the next exhibit is. Six.
Actually, take that minute. I don't know what the video is for 1, 2, 3, 4.
It's a collective, Your Honor, and I
These-
probably failed to move those into evidence after they were authenticated. So I would ask that those be the next numbered exhibit.
No
Just
objection.
be set.
Okay. Deputy Edgars, I'm going to hand you a document that's labeled right now as Exhibit 7. And up at the top, does it say Blount County Sheriff's Office General Order 1.05?
It does.
And is that the use of force policy from the Blount County Sheriff's Office?
Yes, it would be.
And is that the use of force policy that was in effect as of February 8th, 2024?
Yes.
And is that in fact the use of force policy that you reviewed in preparation for your testimony here today?
Yes.
And do you recall that that policy says deputies are authorized to use only the amount of force necessary to accomplish lawful objectives?
Objectively reasonable, yes.
Yes. And that when feasible based on the circumstances, deputies will use disengagements, area containment, surveillance, waiting on a subject, summoning reinforcements, calling in specialized units in order to reduce the need for force and thereby increase deputy, suspect, and civilian safety. Do you recall that?
Can you refer, or can you show me what you're referring to?
Use of force policy, page 4.
Page
Care about that copy? I know you offered it.
Yeah, sure.
Thank you. Where are we at, page 4?
Page 4.
Yes.
And you're aware that the use of force policy at page 2, section 1.0501, about tasers.
My page 2 is just a couple lines, so what was the number that you
Oh, well, I
said?
may have the wrong number.
Okay.
Can I look at that with you?
Yeah.
Yeah, first, again, Judge.
That was.
Yeah, that's your,
Page
no,
2.
that's not page
Oh,
one
okay.
point oh five oh one.
Okay.
That's my fault. I gave you the wrong one. You aware that this policy talks about tasers?
Yes.
Okay. And that it describes tasers as less lethal force than a firearm?
Yes.
All right. And you'd agree with me, based on your training, that a taser can be lethal force, right?
Could be.
Yes. It's just not considered as lethal as a firearm, correct?
I would say it's less than, I don't know, I'm not an expert on the matter, but it's a less than lethal tool, so,
That's what you've been trained.
yes.
Let's talk about your background. Back in February of 2024, you were 22 years old, is that right?
That's correct.
And I believe you said you started employment with the Blount County Sheriff's Office around 2019.
That's correct.
And what was your position with the Blount County Sheriff's Office at that time?
I worked in the jail, I worked in adult corrections,
And how long did you work in the jail?
approximately 3.5 years.
And did you go to a law enforcement academy?
I did.
And how long was that academy?
The corrections academy is 4 weeks, my initial training for that, and my training academy for the road, for patrol was 13 weeks.
And when did you do that training academy for the road?
August of 2022 is when I started, November of 2022 is when I finished.
When you finished? And when did you first go out on the road?
I believe late December, early January. So late December of 2022, early January of 2023.
So at the time of your interaction with Mr. DeHart on February 8th, 2024, you had been on the road a little over a year, is that correct?
Correct.
You talked on direct examination about Mr. DeHart's general demeanor when you pulled him over. Do you recall that?
Yes.
And I believe you said that he appeared nervous, right?
Yes,
And have you ever been pulled over?
I have.
And have you ever been arrested?
I have.
When you've been pulled over, was this before you were a law enforcement officer?
No, it was law as well.
While you were a law enforcement officer, were you pulled over in Blount County?
I was.
And do you understand, or would you agree that someone who's not a law enforcement officer could be nervous just by being pulled over by law enforcement?
I'm going to object that calls for speculation, Your Honor.
She can say it based on her training and experience.
Whether or not someone who's not a law enforcement officer would feel nervous when they're pulled over, that would depend on the person. That would call for speculation.
She's a person too. She's a law enforcement officer and she's also a regular person. Can you give your,
I would say, and I'll give an example. I was slightly nervous when I was pulled over, but I believe there's a difference in being nervous about being pulled over and being nervous about something further. I guess there's a level of nervousness. I would describe it as.
Right, and you would agree with me, though, that just being pulled over by law enforcement could make someone nervous, correct?
Yeah.
And being pulled over by law enforcement at night could alter that level of nervousness. Would you agree with me?
Maybe. I'm not sure.
Jed, obviously, you're Caucasian, is that correct?
Yes.
And you can't speak from personal experience the level of nervousness that a African-American man could feel being pulled over by an officer.
I'm going to object both to relevance, both to speculation, and how that has anything. She cannot have a basis of knowledge in that. It's irrelevant to a probable cause hearing. Respectfully, the state objects upon both
Abstain.
The bottom line is nervousness in and of itself is not an indication of any criminal conduct. Would you agree?
I would agree.
When you were interacting with dispatch, and I think you talked about this somewhat on direct examination, but I'll ask you a few more questions about this. When you were interacting with dispatch on, after you had pulled over Mr. DeHart, you said at several indications, code 4. What's code 4?
It just means I'm okay.
Means you're okay.
Yeah.
And so, if I heard correctly, your direct examination testimony, you call in to dispatch, you let dispatch know what you're doing, that you're attempting a traffic stop, correct?
Correct.
And this was on February 8th, after you had followed Mr. DeHart, right?
Yes.
And so, when you called in to dispatch, you used the word code 4, or the phrase code 4, and that meant that you're okay, right?
Yes.
And if I understood your direct examination testimony correctly, Officer McCowan, over the radio, over dispatch, chimed in and asked you if you needed any assistance.
Yes.
And I believe you said, I'm code 4, but you can come anywhere.
Mhm.
Is that correct?
Yes.
When you pulled over Mr. DeHart, I believe you said that you observed him moving within his own lane initially, is that correct?
Yes.
And then you saw him cross over the center line a few times, is that right?
Yes.
And we've already watched your video, and does your video accurately portray what you were seeing that night?
Yes.
And if your video doesn't show Mr. DeHart about to run into some other car, would that be accurate?
Yes.
And there are any number of reasons why someone may not stay in their lane of travel that don't have anything to do with criminal conduct. Would you agree with me?
Yes.
And Mr. DeHart gave you a reason. He said he was putting up his hair, his dreadlocks, correct?
Correct.
And there's also any other number of reasons. A vehicle, modern vehicles have all sorts of video equipment contained in them. Is that right?
Yes. Sure.
Screens.
Yeah.
They have screens, they have buttons, they have any number of things that can distract a driver.
Yes.
And you've been trained about that, right?
Yes.
And when you initially pulled Mr. DeHart over, this road that you were on, it's a two-lane road, correct?
Correct.
It's, for lack of a better word, out in the country off Sevierville Road, or on Sevierville Road, right?
Yes.
And that's sort of a back way to get to Sevierville if you don't take the interstate from Blount County, correct?
Yes.
And it's a sparsely populated road in places, right?
Yes.
And the area where you initially pulled Mr. DeHart over, there, and where he, once you turned on your blue lights, your emergency equipment, he proceeded a little ways down the road before he completely stopped, correct?
Yes.
And there's no easy way to pull off just to the shoulder of that roadway, correct?
Right.
And to completely get your vehicle out of the road, correct?
Yes, unless pulling into the driveway or the sideway.
That's right, just pulling into the driveway. And in fact, on the video, it shows that the spot where Mr. DeHart stopped, immediately to the right of the pavement, there's not really a shoulder, correct?
Correct.
And there is, the earth goes down right after the pavement, correct?
Yes.
So you can't even pull off into the road and just get into the grass on the side of the road. Your vehicle would go down that embankment, correct?
Right.
And so it's dark, right, at that time? You have to answer that now.
Oh, yes, I'm sorry.
And it's dark at that point in time, and then you get out of your vehicle, you approach Mr. DeHart's vehicle, right?
Yes,
And you interact with him and you ask him to pull ahead to a driveway, that way, and that, you know, for him to get out of the road, correct?
yes,
And when you had that initial interaction with him, you didn't tell him, pull all the way into that driveway so I can get behind you. You didn't say that, did you?
I did not.
And so you told him to pull into the driveway, and Mr. DeHart complied with your command, right?
Yes,
And so he pulled into the driveway, but he didn't pull, he pulled enough into the driveway to get his vehicle off the roadway, right?
yes,
But didn't pull far enough in for you to get all the way behind him into this other person's property, right?
yes,
And so then you got out of the car and you told Mr. DeHart, go ahead and pull forward like you're gonna go to, like you live in that person's house and you're going home, right?
yes,
And did he comply with that command?
he did.
And he pulled all the way in there, and then you were able to pull and get your vehicle completely out of the roadway.
Yes,
And then you approached Mr. DeHart's driver's side of the vehicle, correct?
yes,
And he rolled the window all the way down, right?
yes,
He didn't just partially crack it to speak with you, but he rolled it all the way down, right?
yes,
You had a clear view of the inside of the vehicle where Mr. DeHart was sitting.
yes,
There was like a cookie container on the top of the dash of the vehicle, right?
yes,
And there were junk and papers and other things in the car, right?
yes,
And you spoke on direct examination about how Mr. DeHart was talking and telling you things about where he'd been that evening and what he was doing. Do you recall that?
yes,
And do you recall that in the course of talking with you, he was conveying to you, I'm not doing anything wrong, here's where I'm coming from. Do you recall that?
yes,
And he told you he'd been at his son's basketball game at Gatlinburg-Pittman High School, right?
yes,
And that he was on his way home, right?
yes,
But he had stopped at his grandmother's house to see some home renovations that were being done at his grandmother's home, right?
I don't know if he said that he'd stopped, but I know that he showed me a video.
He showed you, he wanted to show you a video.
Yes,
He was trying to explain to you what he had been doing, where he had come from, where he was going. Is that correct?
I believe so.
Yes. And he even wanted to show you some proof of those things by showing you a video of the renovations at his grandmother's home, right?
Yes,
And you even asked him. He didn't spontaneously say these things. You engaged in a conversation with him, right?
yes, I asked him where he was coming from, and then he said he was on his way home, and I asked him where it was that he lived.
Right. And he was attempting to respond to your questions, correct?
Yes, he did respond to my questions.
And he got his driver's license and was able to provide it to you, right?
Yes,
He told you it was not his car, it was his grandmother's car.
yes,
And he then started, while he was answering your questions, he was trying to gather together the registration as well, right?
yes,
And he went to the glove box and dug in the glove box and was able to hand you the registration.
yes,
And then when you asked him about the insurance, he started digging into the glove box. He said, it's my grandmother's car, and then, do you mind if I call my grandmother and get her on the phone? You remember that?
yes,
And you called her, didn't you?
he did.
And at that point in time, you told him, you just talk to her about that. I'm going to take your license registration. I'm going to go back to my vehicle. You recall that?
Yes,
And then when you went back to your vehicle, you have a computer in your vehicle, right?
yes,
And you entered in the information from Mr. DeHart's driver's license into your vehicle, right?
yes,
It came back as a valid license.
it did.
And then you entered the information concerning the registration on the vehicle into your computer, right?
Yes,
And it came back as registered to Miss Jolene Cagle, correct?
yes,
And the person that you came to know was Mr. DeHart's grandmother, correct? The lady that you spent some time talking on the phone later, correct? And in fact, Jolene Cagle was the name on, I think you said, he had like 12, 15 different types of insurance cards in the car. It was her name on those insurance cards, correct?
I believe so.
And as you're back there and you run your computer, you also were able to see whether or not there are any active warrants, any active process for Mr. DeHart where he needs to be arrested, correct?
Yes,
And also, as you're able to look in the computer, you can do a full NCIC search, correct?
yes.
And a full background check on the person, correct?
It's not a background check, but it will allow you to see if they have any outstanding warrants that have been entered in the
That have been entered in NCIC. It's only as accurate as what's been entered into it, right?
Right, yes,
Okay. And then while you were doing that, you also called dispatch and you asked dispatch to check Knox County and also check Sevier County for Mr. DeHart, right?
yes,
And then you also called Deputy McCowan on his cellular phone, from your
Yes.
cellular phone, right?
yes,
And at that point on the call, and it was played in your body camera video portion, you told Deputy McCowan that you smelled weed, correct?
yes,
Now, you listened to your TBI interview, right?
yes,
And on your TBI interview, when you were interviewed by a TBI agent, you were interviewed by a TBI agent approximately a week after this incident, is that right?
yes,
And you're interviewed by that agent about a week after this incident, and you had a lawyer present, your own lawyer present for that interview, right?
yes,
And you wanted to answer those questions completely, right?
yes,
Accurately, correct?
yes,
Truthful.
yes,
And during that interview, when the TBI agent asked you when you smelled weed, you said, I'm going to be 100% honest with you. I did not smell weed, I did not smell marijuana until I went to the passenger side of the car, correct?
I believe so.
Now, while you're still back in your cruiser, I'm going to take you back to when you're in a cruiser and you're running these checks on Mr. DeHart. You got word back from dispatch, and if I got the timestamp correctly, it was about 2011-15 on the video. You got word back from dispatch that there were no warrants on Mr. DeHart in Sevier County or Knox County, correct?
Yes,
But it was another roughly 3 minutes before you got out of your car and approached Mr. DeHart's vehicle. Is that right?
yes,
So at that point in time, you had already been informed, no outstanding warrants concerning Mr. DeHart, right?
yes,
And you weren't able to see anything on your computer to show there was any outstanding warrants, correct?
correct,
You had a valid license, correct?
correct,
He was driving a vehicle that was a family vehicle owned by his grandmother, right?
correct,
That had a valid registration, right?
yes,
And so you now go back to the vehicle. After getting that information, you still wait 3 minutes to go back. Of course, you talked to Deputy McCowan, right?
yes,
And Deputy McCowan had told you that he was over in the area of Blount Memorial Hospital, right?
yes,
And the area of Blount Memorial Hospital is all the way almost to Maryville if you're going down Sevierville Road, correct?
yeah, probably 15, 20 minutes.
About
Yes.
15, 20 minutes down that road. And the area that you were in was still in Blount County, but closer to the Sevier County line of Blount County, is that right?
Yes,
And so Deputy McCowan told you he was on his way, but it was going to take him a little while to get there, right?
yes,
And that's why you waited some period of time, an additional 3 minutes or so, before you got out of your patrol vehicle to approach Mr. DeHart's car.
yes,
So you then approached Mr. DeHart's vehicle, or his grandmother's vehicle, on the passenger side, right?
yes,
And I think you tapped your flashlight, is that right?
yes,
You tapped your flashlight on the passenger side window. And at that point in time, he rolls his window all the way down, right?
yes,
And he doesn't just roll it down partially, he rolls it all the way down, correct?
yes.
stand there and you engage in a conversation with him, right?
Yes,
About the insurance cards, correct? And he still has his grandmother on the phone at that time, right? And you introduce yourself to the grandmother, Miss Taylor, right?
yes,
And you speak with her and talk to her about the insurance cards, right?
yes,
And you say, I'm not worried about the insurance cards. You got like however many, 14, 15 insurance cards. I'm not worried about that, correct?
yes,
And at that point in time, you then tell Mr. DeHart that you smell weed, you smell marijuana coming from the car, right?
yes,
And you tell Mr. DeHart at that point in time that he needs to get out of the vehicle, right?
yes,
And you tell him that he needs to get out of the vehicle because you have probable cause to search the vehicle at that point, correct?
yes.
You did not tell him, I need you to get out of the vehicle so I can conduct field sobrieties on it, did you?
I did not tell him.
And in fact, you told him, I'm not saying that you're smoking weed, I'm just saying I smell weed in the car, right?
Yes.
So let me ask you about the smell of marijuana for a moment. When you went through the academy, did you go through different sorts of training on smelling contraband?
No, not of actual contraband. We discussed it, but I did not actually smell marijuana in the academy.
Okay, so you've had no official training on the smell of marijuana,
Other
correct?
than field training,
Field training.
yes,
And when you mean field training, you mean just being out on patrol and you pull someone over and you smell marijuana and you conduct a search and there's actual marijuana in the vehicle,
yes,
all right? Would you agree with me that marijuana that has not been smoked or has not been burnt has a different smell than smoked marijuana?
I'm not sure. I don't know that I would be able to tell you the difference.
You would not be able to tell the difference.
I would not be able to describe to you the difference.
Have you been around cigarette smoke before?
Yes,
And have you been around substances that have been smoked?
yes,
Are you able to tell the difference between an area where there has been smoke or the particulate matter with something burning present versus a smell that has nothing to do with the particulate matter of smoke?
yes.
So that night, what kind of weed did you smell? Smoked or non-smoked?
Objection, she stated that she can't tell the difference between smoked and unsmoked weed. That's her testimony. That's what she testified to. But asking her which one she smelled, I think based on her response, is asking her a question she already said she cannot answer.
Well, I think he's just testing her on that, and he's allowed to do that. If you can answer the question.
Thank you.
He's just getting around to it again. It's up to you. Can you tell any difference if marijuana just sitting there or that it's been smoked?
I would say like if it's actively smoking, maybe I could tell the difference. But if it's not actively smoking, I don't know that I would be able to tell the difference between the two distinct odors. Distinguish between the two odors is what I mean to say.
And I think you said you've been on patrol for about a little over a year at this point, correct?
Yes,
And you said your only training with respect to smell of marijuana came from your experience in the field. Is that right?
yes.
You had no other experience with the smell of marijuana otherwise?
I mean, other than just general life experience,
Have you ever smoked marijuana?
I've not.
Have you been around others who've smoked marijuana?
I have.
And are you able to tell the difference between legal THC and non-legal THC?
No.
And so, and what I'm, in all fairness to the directors, what I'm just trying to get at is, given the fact you told TBI a week later, honestly, you didn't smell marijuana. Those are your exact words. You tell the TBI agent, because you know you're being interviewed by the TBI now in a use of force investigation. And you tell the TBI, honestly, I didn't smell marijuana until I went to the passenger side. Okay? And so, given your inconsistent statements about that, I'm trying to get at what you smell. Okay? And that's all I'm trying to get at here. So, when you went to the side of Mr. DeHart's vehicle, are you able to give any better description of what you smell other than just say you smell weed?
I smell the odor of marijuana that is consistent with what marijuana has smelled like in my training and experience.
Okay, and that training and experience being the year that you've been on the road.
Yes.
And so that year you've been on the road, had you ever been involved in seizing fresh green marijuana?
Yes.
Have you ever been involved in being around marijuana that had been smoked?
Yes.
Have you ever been involved in being around hemp or legal THC?
At the time of my training, I don't think very much. That I just started dealing with that, I guess, probably at the time of this incident, but yes, occasionally.
And you agree with me that there's no, you can't smell the difference between the two?
No, I don't believe so.
And so the smell, whatever you were smelling, I think you described it on direct examination as sort of like a skunk, but less chemically, is
Yes.
that right? Whatever you were smelling, it could have been a legal substance, or it could have been an illegal substance. You did not know, correct? And so, let me go back now to, you're on the side of the vehicle, passenger side. Jolene Cagle is on the phone. Mr. DeHart is in the car. He's rolled his window all the way down. You told him that you don't care about the insurance because they got tons of insurance cars in the car. And you tell him you need to get out of the vehicle because I have probable cause to search the vehicle, correct?
Correct.
And Mr. DeHart tells you that he's not been smoking marijuana, correct? His grandmother says no one's been smoking weed in that car, correct?
Correct.
They say that would mess up the leather seats, right? And Mr. DeHart, while still in the vehicle with both windows rolled down, with his grandmother on the phone, tells you, I'm refusing consent to the search. I don't consent to it. You recall that?
Yes.
And at that point, you don't tell him, I want you to get out of the car, not so I can search it, but so I can conduct field sobriety examinations of you, right?
Correct.
In fact, at no point in time did you tell him you wanted him to get out of the car for any other reason than to conduct a warrantless search of the entirety of the vehicle, correct?
Yes, I told him as long as, I believe I told him as, we'll search and as long as everything checks out okay, then you can be on the way. I did not specifically state that I wanted to do field sobriety testing.
Right. Or do anything else. We're to search him, correct?
Correct.
You told him, I want you to get out of the car so I can conduct a search of your vehicle. And if I search it, and when you mean search it, you were going to search the whole car, right?
Anywhere that marijuana would be present, yes.
Anywhere. You were going to go through the trunk, you were going to go through the dash, you were going to go through any container in that vehicle, correct?
Yes.
And you told him, I'm going to search the car, that's why I need you to get out, right?
Yes.
And you were telling him he had no choice, right?
Yes.
You were commanding him to get out of the car because you said you had probable cause based on the smell of marijuana.
I'm going to object to ask and answer several times.
Sustained.
And Mr. DeHart refused that consent, right?
Yes.
And at some point, Mr. DeHart gets off of the phone with his grandmother, correct?
Yes.
And he tells her, before he gets off the phone with her, that he believes he's being pulled over because he's black, right?
Yes.
Or at least treated the way he's being treated because he's black, correct?
Yes.
And then he tells his grandmother he loves her, right?
Yes.
And then he makes another phone call. You recall that?
Yes.
All the while you're telling him you can't refuse consent, you have to get out of the car, right?
Yes.
And he calls another female and asks her to tell you he doesn't smoke weed, correct?
Yes.
And she does so, right?
Yes.
And then he has a conversation with her where he asks her to come to him, correct?
Yes.
And you've been trained in DUI stops, correct?
Yes.
And as part of that training with DUI stops, you're aware of the fact that if someone is impaired, a non-impaired person can drive the vehicle away, correct?
Yes.
And so, consistent with your training, you could have asked Mr. DeHart to exit the vehicle for the purposes of field sobriety examinations, right?
Yes.
And a third person, this other female he called, who he said where he was and said to come there, this third person could have driven the vehicle away, right? Under that scenario, a third
Under
person.
that scenario, yes.
Yes.
I had to further my investigation, so I don't know what decision would have been made.
Sure, I understand, but under the hypothetical I'm posing to you, under that scenario, if Mr. DeHart had gotten out of the vehicle, if you'd conducted field sobrieties on him, and this third person had come, the third person could have driven the vehicle away, right?
Yes.
But Mr. DeHart was never given that choice, was he?
No.
At some point after this conversation that Mr. DeHart was having with the female, Deputy Edgars arrives, correct?
Deputy McCowan.
McCowan, I'm sorry, Deputy McCowan arrives, correct?
Yes.
And Deputy McCowan arrives, if I recall correctly, we're now at about 8:21 p.m. on your video. Do you recall that?
Yes.
All right. And so, that's going to be roughly 10 minutes after you were told by dispatch there were no active warrants on Mr. DeHart, correct?
Yes.
And Officer McCowan arrives, and we've seen that the video footage that's in evidence now. Officer McCowan also tells Mr. DeHart to get out of the vehicle, correct?
Yes.
And both you and Officer McCowan are able to see Mr. DeHart and see inside the vehicle fully because both the passenger and driver's side windows are fully down, correct? And during this time, when you had a view of both the driver's side and then the passenger side of the vehicle, you never saw any weapon in the car, right?
I didn't.
You never saw Mr. DeHart reach for or grab a weapon.
I didn't.
And shortly after Officer McCowan arrives, you then leave the passenger side of the vehicle and you go over to the driver's side of the vehicle. Is that correct?
Yes.
And the video evidence shows that you continue to have a dialogue with Mr. DeHart about you're not going to get a drug dog. He has no choice. He has to get in the vehicle, correct?
Yes.
And you eventually, he does start attempting to roll the window up, the driver's side window up, right?
Yes.
And you reach your hand into the vehicle at that point, and you open the vehicle up, right? And when you open the vehicle up at that point, you then enter the vehicle through the opening of the driver's side door, right?
Yes.
And when you open the vehicle at the opening of the driver's side door, you start engaging in physical contact with Mr. DeHart, right?
Yes.
And you start trying to reach around him and to take off his seatbelt, right?
Yes.
And I believe you described it on direct examination as Mr. DeHart hitting you. Let me talk with you about that for a moment, okay? As you are in the vehicle, Mr. DeHart is not punching you, is he?
I don't believe so. I think I described it as he was actively resisting.
Actively actively resisting. So help me understand that. What exactly is he doing from your perspective?
He is using his hands to prevent me from doing what I need to do.
So using his hands to prevent you from unhooking the seatbelt?
Yes,
And Mr. DeHart's quite a bit larger than you, is that right?
yes,
And to unbuckle his seatbelt, would it be fair to characterize that the seatbelt is, particularly the lap portion of the belt, was obstructed somewhat just by his body?
I do not recall, but maybe,
All right, and so you were having to get a significant amount of your upper torso into the vehicle just to reach over Mr. DeHart, is that fair?
yes,
And you said he was using his hands to sort of keep you from unhooking his belt, is that right?
yes,
And that was, when you say hit, that's the only sort of physical contact he was engaging in with you, right?
I think she said she did not say that.
yes, I believe I
You said, I don't know what you said, but pushing.
pushed
Using
him,
his hands
having
to push
him.
your arms
I
away.
mean, I'm not necessarily saying he was pummeling my face in, that's not what I'm describing. And I'm describing what's on the video. You can see from a different angle that he is shoving, trying to pull my arms down, things of that nature.
Okay. And certainly your, Judge, your recollection is probably better than mine. I just wrote in my notes hit.
Watched a lot.
I just, when she testified on direct, I just made a note about that. I was trying to probe into that. All right, thank you for clarifying that. And so when you can't get the seatbelt off, you then remove your torso from the vehicle, right?
Yes,
And after you remove your torso from the vehicle, by that point, Deputy McCowan has his taser out, correct?
yes,
And he has it pointed in the direction of Mr. DeHart, right?
yes,
And when he has the taser out and pointed in the direction of Mr. DeHart, after you had tried to get the seatbelt out, the two of you continue to engage in commands to Mr. DeHart to get out of the vehicle, right?
yes,
And he continues to tell you, I did nothing wrong, get a drug dog, please, right?
yes,
And you then tell Deputy McCown, hit him, right?
yes,
And you meant shoot him with the taser, correct?
yes,
And there were 4 taser shots, correct?
yes, yes,
Yeah, let's break that down a little bit. So the first taser shot, and the way a taser works is it's sort of like a forced air projectile. Is that an accurate way to say that?
yes,
And so 2 prongs are come out and they embed into the skin of the other person, correct?
yes,
And they embed into the skin of another person, and that's to emit an electrical charge into that person's body, right?
yes,
And the reason for that is to incapacitate that person, correct?
yes,
And by incapacitate, we mean that they're going to lose motor control, right?
yes,
And it's going to have a neurological impact because it's affecting the way in which the brain is dealing with its electrical signals.
I'm going to object that that calls for expertise in the medical field of neurology. This officer is not possessed, and it's not, foundation hasn't been laid for it.
So far, I sustain the objection.
All right, well, you recall your prior preliminary hearing testimony, did you look at that or read that?
yes,
You did. Do you recall testifying at the prior preliminary hearing about tasers and
Yes.
the impact of tasers?
yes,
Do you recall that? Do you recall testifying that tasers hurt like hell?
yes,
Do you recall saying that it completely incapacitates you?
yes,
And do you recall testifying about, and also in your TBI interview, talking about how there can make you confused afterward? Do you recall that?
I don't know that I've described it that way.
How would you describe it?
I'm not sure what you're referring to. Did I say that it would confuse you?
Well, I'm going to try to, at one point in your TBI interview, you said, I was still feeling the effects of the taser after you got tased,
Yes,
correct?
yes.
And feeling the effects of the taser, what do you mean by that?
I would say I stepped back, I just had to say, okay, that didn't work, let's try something else. I had to think through what my next step would be.
And so, immediately after getting tased, are you talking about the, for lack of a better word, the cognitive sort of impact of immediately the after effect of that? The mental impact?
Could you maybe rephrase that?
Sure. What I'm getting at is, from being tased, I mean, you testified before, and you've said here today that it incapacitates you.
Yes.
What do you mean by incapacitate? I'll ask it that way.
In layman's terms, you locked up, your muscles locked up, and you don't move. Or, well, that's the effect on a lot of people. It doesn't affect everybody the same way, but the effect on a lot of people is that you lock up and can't move, and that way it's used as a tool so that we can gain control of someone.
Gain control of
Custody.
someone, and, I'm sorry, I didn't mean to talk over you.
No, you're fine. And effect an arrest, take them into custody, detain them, so on and so forth.
Yeah, and it's painful,
Yes,
right?
yeah.
And when Mr. DeHart was being tased, you could tell that that first tasing, I think you said that it was a bad connection. That means the metal didn't go fully probably into the skin. Is that right?
I'm assuming. I don't know exactly what happened, but he was able to pull it out.
He was able to pull it out.
Yes,
And, well, obviously the second, third, and fourth tasings, you were able to observe those had a different effect on Mr. DeHart than that first tasing, right?
yes,
And his body seized up, like you're talking about, correct?
yes,
And he cried out in pain, right?
yes.
And so that was, so with the second tasing, that occurred right as the door was getting shut to the driver's side vehicle, right?
Yes,
And so the second, third, and fourth tasings in sequence there, you could tell Mr. DeHart was seizing up, and he was talking about, he clearly was making noise indicating he was in pain, right?
yes,
And you were able to open the door, and you attempted again, while he was being tased, to take his seatbelt off, correct?
yes,
And this was already into the third full-on tasing,
yes.
is that right?
The second.
A
The
second,
full-on tasing.
The second.
Full-on tasing, but I guess technically the third round or
the third round of
tasing,
tasing.
yes.
If we say the first one was not full impact,
Yes,
You know,
this would be the
let's talk
second, the second effective one.
the second full-on impact tasing,
Yes,
okay. And that's when you reach in, and I think you described it as, you touch the leads, correct?
yes, the wires.
The wires, they got on you. And so, you were not impacted by the wires the entire time that full-on tasing occurred, right?
From the time that my arm touched him until the end of the cycle.
Right, but it had already started before you, what I'm saying is that you didn't get the entire cycle of that tase.
No,
You got a partial cycle of that tase.
yes,
But it affected you, right?
yes,
And it hurt you, correct? And you were asking Deputy McCown to stop, correct?
yes,
And then, right as you walk away, you said, I've been tased, right?
yeah.
And do you recall testifying before about a taser? It makes you feel like your muscles are trying to jump out of your body.
I
Recall
would say
that?
that's the best description of how it feels, yes.
Right.
To me anyways, that's how it feels to me.
And it disoriented you?
While it was happening, yes.
Well, you've already talked about that you recall being interviewed by the TBI, and you've listened to your TBI audio recording, right?
I have.
Okay. Well-
other than just play the tape.
Yeah, and what I was gonna do, Judge, and I'll lay a little bit more foundation. So, you said you were obviously interviewed by the TBI, and do you recall being questioned about you being tased that evening? Do you recall that?
I do, I believe that's where you quoted me and I said it hurt like hell.
Well, that was actually your preliminary hearing.
Oh, okay, sorry.
Okay, and so, do you recall whether or not, you mentioned, or you said to the TBI agent that even one taser shot less than 5 seconds can disorient you? Something to that effect, or there's a conversation to that effect?
I don't recall, I don't know that I'm tracking the proof.
And Judge, I can play it just for the witness, we don't have a jury here.
No, that's fine. You've asked, you did what I asked you to do, which was ask her.
Yes,
She
sir.
says she doesn't remember, so if you've got it, play it.
Yeah, and I do, and I've got it paraphrased here, but let's just,
No.
let's just play what you actually said.
Yeah.
Okay.
All right, let's see if we can. We'll go just a little bit before.
Here, and reached across, and I went like this, and I couldn't move, and I said, Greg, you got it.
I'm gonna pause that. Do you recognize your voice on that recording?
Yes,
And you've listened to this recently, correct?
yes,
Do you remember this actually is your interview with the TBI agent?
yes. I don't remember exactly what I've said here.
Greg stopped, Greg turned off, Greg, no. And I wrote almost the full 5 seconds. Greg did turn the taser off. Because I got hit, I was disoriented a little bit.
So I'm gonna pause it right there. Because you got hit, you were disoriented a little bit,
Yes,
all right? You recall saying that?
yes,
And so you understand what I'm trying to get to here is that just the being disoriented during the tasing wasn't just the issue, you were also disoriented after the tasing as a result of it, correct?
yes. I think it was more of, I didn't expect to get tased and I had to find a way to deal with the situation other than that because 2 of my game plans have already failed of removing Mr. DeHart from the car.
I understand that.
Yes.
But what you said to the TBI was you were disoriented a little bit after that, correct?
Yes,
All right. Now, that was so don't get confused with the numbers of the tasings. What we'll call the second full-on tasing, correct?
yes,
And after that, you step back and Deputy McCowan then begins the third full-on tasing, the full impact tasing, correct?
yes,
And it's during that tasing that there are 3 gunshots, right?
yes,
And those 3 initial shots were sort of clustered together, right?
yes,
And you believe that the first shot is what impacted you in your leg, correct?
yes,
And you believe the next 2 shots are what impacted Deputy McCowan,
at least one of them, yes.
at least one of them. Approach the witness, sir.
Yes.
Now, you said you recall testifying in the prior preliminary hearing in this case, right?
Yes,
And do you recall testifying that you believe the second and third shots hit Deputy McCowan?
I'm not sure, could you tell me what you're, or show me what you're
Sure.
referencing now?
I'm going to go to the transcript of preliminary hearing, page 41, lines 1 through 3. Approach the witness, Judge. All right, let's get to it. see where we're at. You see that you're the witness in this transcript,
Yes.
answering the questions, is that correct?
Yes.
Okay. So I'm now gonna go to page 41. And I'll start at page 40, okay? And we'll start at page 40 and line 22. And if you'll just kind of read from there, let me know.
I believe it's, you want me to read that loud?
No, you just read it to
Okay,
yourself.
okay. Okay.
All right, so you recall testifying before that you didn't really see the second and third shot, but you believe the second and third shots hit Deputy McDowell.
Yes, because I knew that he had fallen down.
Right, you fell down pretty quickly, right?
Yes.
And I think you testified that at no point did you ever see a firearm, correct?
Correct.
You just heard the shots.
Yes.
And obviously you were able to observe what happened to your body, and you saw what happened to Deputy McCown, correct?
I did not see what happened to Deputy McCown, but I have been told what happened to Deputy McCown.
You saw him fall.
Oh, yes, I'm sorry.
Yes, I'm sorry, that's what I meant.
Yes.
You saw him fall,
Yes,
correct? And you were able to hear these 3 gunshots, correct?
yes.
Have just a moment, Your Honor. Yes, sir. Just want to make sure I've hit what I need to hit. Covered one point that I failed to cover. Your initial interaction with Mr. DeHart, when you had pulled him over, you've given him commands to fully pull into someone else's driveway, and you've gotten behind him. We're at that point, okay? And when you go up to the driver's side of the vehicle and you're engaging with him, one of the things he tells you is that he's tired, right? He's tired, he's ready to go to bed.
Yes.
Okay. And we talked about the different things that could cause someone to maybe weave a bit in the road. And
Hold on, may I interrupt you? I'm sorry. When you're saying that he said he was tired, was that the third interaction that we had? When I say third interaction, I mean.
the very first interaction.
Okay. Okay,
The very
sorry.
first
I just want to make sure I was
Yeah.
following.
Yeah, the very first interaction. And so what I'm getting at is, we talked before about the different things that could affect motor control of a vehicle, right?
Right.
And we talked about distracted driving and all the stuff that are in cars right now that can distract a driver, correct?
Right.
And one of the other things that can impact a driver, of course, is tiredness, right?
Yes.
And that's another non-illegal way that someone could swerve in the road a little bit,
Yes.
correct? All right. Let me go back to the computer screen in your vehicle from that evening. And you talked about that when you got back to your cruiser, you were able to driver's license, you're able to look up the registration, able to take a look at NCIC, right?
Yes.
And when we watch your body camera video when you were in your car, when it shows you clicking, it looks like you're clicking on things with a mouse on your screen. Is that what you were doing?
Yes.
And when you were doing that, is that what you were doing? Were you looking up these various things concerning Mr. DeHart?
Yes, so I looked up all of the information that you just described. I was actually previously on my way to another deputy who had made a traffic stop and was currently making an arrest, so I clicked through to find that call to see where she was at with that. And then I checked the map. We have a CAD map system with a GPS in our car. I checked the map to see where Deputy McCowan was and approximately how long it would take me to get to him.
Right, and that's why you testified earlier. It's one of the reasons why you stayed in your car. You wanted to give him time to get to you.
Yes.
All right. And also some of the other things that you were doing in the car, if I understood you correctly, you were checking on what another officer was doing with another traffic stop that you were on your way to. Is that right?
Yes.
The computer screen in your car, are you also able to ascertain whether or not there's any active investigations into someone?
If there is I don't know a way to describe this, I may not be able to describe this correctly, but if there is a report that like a patrolman makes, I can read the report, and I can click a bunch of buttons and go into some background stuff in the actual Flex system. We have two different systems, mobile and Flex. I can go into the background of that and see maybe if, see follow-up notes from detectives if they've investigated something, but the screen that I was on currently, no, I couldn't see anything about any kind of investigations, if that's what you're referring to.
That's what I was referring to.
Yes.
So you could have looked those up in your vehicle, and you could have run Mr. DeHart in any active investigations. You didn't do that.
No.
That wasn't part of what you were doing when the video shows you your mouse going around and clicking on things. That's not it.
No, I
Correct?
just kind of skimmed through the reports that had been taken, the incidents that he had been involved in our county.
Right. And then you were taking a look to see where Deputy McCowan was, and then you went to working on something else that didn't have to do with Mr. DeHart, correct?
Yes.
Nothing further at this time, Your Honor.
Thank you, Mr. Johnson.
Thank you, Your Honor.
One quick question on the tasing. Here's what I got out of this. There were actually 4 separate cases. The first one was completely defective.
Correct.
Really 3 that didn't.
Yes.
Fair enough. General.
Excellent. Well, can I ask a follow-up based on your question?
Of course you can. Go ahead while he's
While he's
first thinking about it. Go ahead.
Okay, thank you. And you're aware that each of these tasings lasted approximately 5 seconds, right?
Yes.
And have you had an opportunity to look at the taser report concerning these tasings?
No.
But you know from your training and from your experience, they last about 5 seconds, correct?
Yes.
And the tasings that occurred here, I'll talk about the 3 impact tasings that had effect. Those were in fairly quick succession.
the state's case for probable cause and proof relevant to the motion to suppress as well as bond.
Okay.
Let me confirm with Mr. Kirk.
Sure.
Gentlemen, we have Dr. Drake, a ballistic physical pathologist, under subpoena, and we told her to be here at about 1 o'clock. And things went a little quicker than anticipated. She may already be here, Mr. Curtis
She's not.
was checking. And so,
Do you have any other witnesses besides?
we don't have any other witnesses. We decided to, given our discussion about the state not wanting to introduce the statement that Mr. DeHart gave at the Blount County Sheriff's Office when he was arrested, it has curtailed our proof today. And so we do intend to present the testimony about the incident.
Would you mind spelling that one for me?
MILEUSNIC.
Okay. Well, I think we'll just have, I mean, we've got 20 minutes for the doctor to show up.
And Your Honor,
Anything y'all want to do in the next 20 minutes?
but we could argue, based on the proof before the court, we could argue the suppression issue. The court wasn't here, any argument concerning that.
Sure. Be glad to entertain that.
Your motion, Mr.
Yeah.
Jones.
So, Your Honor, we have briefed this for the court, and obviously, the court is aware of the law in Tennessee now, is that the smell of marijuana alone is not a basis for probable cause to search a vehicle. It can be one circumstance among many, but it is not in and of itself a basis to conduct a full search of a vehicle. Respectfully submit to the court, the proof that the court is for today, and let me break this down a little bit. The initial investigatory stop was because Mr. DeHart, Deputy Edgars, observed him both weaving within his own lane and then crossing the center line. And I believe she testified at no point, because I asked her this question specifically, did he run into another car or pose a danger to another vehicle? And so she decided to conduct an investigatory stop with him at that time. On cross-examination, we got into some more of the details about what occurred when she stopped him and sort of what that roadway was like. And it was not a roadway that presented itself with a shoulder where he could pull off, or even where he could pull into the grass. His car would have fallen down this embankment. And it's dark, and so after he sees the blue lights behind him, and he goes down a little ways, he just eventually just kind of stops there in that lane of travel. The court has heard that testimony and seen the video. She gets out, she asks him to pull up to a driveway further ahead, and to pull into the driveway and get off the road. She never said, pull all the way in so I can pull in behind you and we'll fully get onto this person's property. And so he does exactly what she commands him to do. And then she gets out, and she says, no, pull all the way up into it like you were going to go home. And then that occurs. That conduct, in and of itself, is nothing but innocent conduct. She was asking him to continue to operate the motor vehicle, and he complied with her commands. She then gets and approaches the driver's side of the vehicle if she's conducting this investigation concerning the weaving, and approaches the driver's side of the vehicle, engages in a dialogue with Mr. DeHart. And it's not a one-sided dialogue. She is asking him questions. She's asking him, where's he coming from? What's he been doing? And he's just been pulled over. Obviously, he's nervous, and he's trying to answer all of her questions and to give her information about, I'm not doing anything wrong, I'm telling you what all I'm doing, and here's some evidence that supports what I'm doing. Here's a video that shows his house, and I can get my grandmother on the phone. And while she later McCowan on his cell phone, I smell weed, I think I have a DUI. She admitted under cross-examination here that when she was interviewed by the TBI, approximately a week later, with her lawyer present in a recorded interview, she told the TBI, to be 100% honest with you, I didn't smell weed when I was on the driver's side of the car. I didn't smell weed. She admitted to the TBI, there's no other way to characterize this other than lying about the smell of marijuana on the driver's side of the vehicle. Mr. DeHart complied with every command she gives him. She asks him, where are you coming from, where are you going, what you've been doing, and then engages in conversation about the cookie company and asks him for his driver's license, which he produces, asks him for his registration, which he produces and says it's my grandmother's vehicle. Asks him for his insurance, and he's not sure where she keeps the insurance, so he gets her on the phone. And she goes, okay, and goes back to her vehicle. And the facts before the court are that while she is in her vehicle, she does more than the purpose of the initial stop. She runs the driver's license, she runs whether or not there's any active warrants, she runs the registration on the vehicle, she takes the affirmative step of also calling dispatch and letting dispatch know, hey, check for me in Sevier and Knox counties as well, which dispatch does. She calls Deputy McCowan, has a conversation with him about where he is, and estimates kind of how far away he is. And then her testimony before you today is she intentionally delays the stop so he can arrive. She intentionally delayed it. And then she starts doing with...
Would that be somewhat prudent if she was worried about her own safety?
If she was worried about her own safety, the court did not hear any testimony that she was concerned for her own safety. In fact, Your Honor, what she told dispatch multiple times, and it's on the video, you can hear it if we played it again. And I asked her about this. The code that she reported.
Oh, I know, she gave the code, I'm fine. I said, wouldn't that be prudent, though? She thought she was worried to have someone there to help her.
Yeah,
Not that she was in trouble, not that she was okay.
And it would be prudent if at that point she's already decided to exceed the scope of the initial investigation and investigate further. And the testimony before the court is that the reason she decided to investigate further and exceed the scope of the initial investigation was because of the smell of marijuana, which she has testified here today that she told the TBI, to be honest, I didn't smell marijuana. So yeah, that would be...
That's not the testimony respectively.
Yeah, she testified here today to something different. You asked about what she told the TBI,
Yes.
whenever that was.
She testified that she told the TBI a week after this, in a recorded interview, to be honest with you, when I went to the driver's side of the door, I did not smell marijuana. Her testimony here today was, that is what she told the TBI. That's what I'm saying. Okay, on direct examination, I would agree with you that she said I smelled marijuana. But she also testified on cross-examination a week after this occurred, when I was interviewed in a recorded interview with a TBI agent and my lawyer present. I said, to be honest with you, that's her exact words. I didn't smell marijuana until I went, after I got out of my car and I went to the passenger side of the vehicle. So, back to this issue of waiting, intentionally delaying the stop until Officer McCowan, to give Officer McCowan more time to arrive, was, if that only basis was the smell of marijuana at that point. And the proof shows that's correct, because then when she gets out of her vehicle, after she goes and does other business and works on another case, and goes to the passenger side of the vehicle, and Mr. DeHart rolls the window down, according to her TBI interviews, she says, that's when I smelled marijuana for the first time. And that's when she says, you've got to get out of the car because I've got probable cause to search the car. It's not something where she's saying, you get to consent, okay, you can refuse, or can I search the car, or I want you to get out of the car so I can do field sobrieties, all right? She's telling him, you get out of the car, I have probable cause to conduct a warrantless search of your car. That's why I want you to get out. And I respectfully submit to the court, under Berrios, she delayed the purpose of the initial stop beyond the purpose of the initial investigation. And to hear her testimony, which is conflicting about when she smelled the marijuana, the smell of marijuana in and of itself was not enough to conduct further investigation in and of itself. And I respectfully submit to the court, the state has the burden of proof here. And right now, the evidence before the court is she testified she smelled marijuana, but she testified a week after the fact, when she was interviewed by the TBI during that initial approach, when she was interacting with Mr. DeHart with the window fully rolled down and engaging in that conversation with him. She said, to be honest with you, I didn't smell marijuana. And I'm going to hand the case up to the court. That's a very recent opinion by Judge Hickson on October 22nd. But it's a recent Court of Criminal Appeals opinion concerning facts and circumstances other than the smell of marijuana not being enough to conduct a search. And here, Your Honor, at the time that Deputy Edgars said, you're seized, you're not going anywhere, you have to get out of the car because I'm going to search it. And I've got probable cause to search it. The only evidence before her, or the information before her at that time, was that he weaved in the road. He'd given innocent explanations for why he had done so. And he had complied with all of her commands otherwise. And the smell of marijuana, even if she smelled it, was not enough with those other details to seize Mr. DeHart and at that time fully conduct a warrantless search of the entire vehicle. She didn't say, I'm seizing you because I want you to get out of the car. I'm not going to search it. I want you to just get out of the car so I can field sobrieties. She said, I'm going to search the vehicle. Get out of the car. I've got probable cause to search the vehicle. And so it's a different analysis than get out of the car. We're going to conduct field sobrieties. And that's why I asked her those questions about Mr. DeHart called another female to come there and to be present. And he was never given that opportunity. So moving on now past that issue, even if the court gets past that purpose, we then get into, and we brief this for the court, this issue of excessive force with Mr. DeHart. There is a Sixth Circuit case that we have cited for the court, granted a lot of authority in this area is in the area of civil rights cases. The excessive force cases that the Sixth Circuit has found that being present in a vehicle and refusing to get out doesn't warrant tasing someone to force them to get out of the vehicle. And the facts and circumstances here, Mr. DeHart had 2 patrol vehicles behind him. He was refusing to get out of the vehicle. There are lesser measures of force than immediately tasing him.
Well, they've been tried. She opened the door, tried to unbuckle the seatbelt. He not only refused, he fought. He didn't. So I guess I'm left with the kind of questions. What was the law enforcement supposed to do after they told him countless times to get out of the vehicle? He said, I'm not going to get out of the vehicle. They tried to physically get him out of the vehicle. He's resisted. They said, okay, we're going to tase you if you don't get out of the vehicle. You still won't get out of the vehicle. What are they supposed to do at that point? I'm asking you.
Yeah, under the use of force policy, that's the reason why I put that in the evidence, Your Honor. Under the use of force policy, they're supposed to use other measures to include waiting on other law enforcement to respond. They could have done that. There are any other measures they could have done. They also did
Okay,
not.
I'm just thinking, what good would that do? Gonna have all of them tackle him at one time, rip him out of the vehicle? I'm just not sure that's gonna be any better.
There's a temporal issue here, Judge, that I really, that answers your question to. And this all occurred, as the court can see from the video, in a matter of minutes.
Yeah.
It all occurred in a matter of minutes. And they did tell him repeatedly to get out of the car. He didn't get out of the car. One of the de-escalation techniques that is in the Blount County policy is, in essence, waiting. And they immediately went, when they did try, and Deputy Edgars testified that she tried to maneuver around him, and he's a bigger man, the court can take judicial notice of that, and the video shows that, she's trying to maneuver around him to get at the seatbelt, and then she gets out. It doesn't take long for them to start tasing him, and the tasings are in the testimony before the court, both in the video and from Deputy Edgars, is that those tasings were in quick succession. And so, under the use of force policy, just to answer the court's hypothetical about what else they could have done, you didn't have to do it that fast. You didn't have to move that quickly. You're supposed to de-escalate under their policy and continue to engage in conversation to de-escalate. And so, escalating that quickly, I respectfully submit to the court, was inconsistent with the use of force policy. But back to the Fourth Amendment issue, on excessive force, I respectfully submit to the court that tasing someone who's not presenting any sort of threat or danger, he's sitting in a car, he's blocked in by law enforcement, but to tase him in rapid succession like that is excessive force under the Fourth Amendment. And then the question becomes, what's the remedy for that? And I know the state in its response said that there's no authority under for an unconstitutional seizure via excessive force, that the exclusionary rule apply. I have found no Tennessee authority that addresses this issue one way or the other. What I can tell the court is, I think that the authority is clear that when you have an unconstitutional search or seizure, that the exclusionary rule applies. Excessive force is clearly an unconstitutional seizure. And I respectfully submit to the court that can form a basis for suppression of the evidence, everything that flows afterwards.
Yeah, you haven't articulated it, so I'm gonna ask you point blank. I think what you're telling me is that, based on that theory, the court should suppress the fact that he pulled the gun out and shot and killed.
Yes, sir. That's why I said it's not limited to physical items that are seized as a result, and I believe the authority is clear on that too. For example,
As far as I can tell, nothing was seized. He drove off in his, right? I mean,
right,
what did anything seized?
there wasn't anything seized. There was, I think there was some shell casings that were found in the ground later by TBI. And, but no, I mean, as the court's aware, a Fourth Amendment violation can form the basis, for example, for suppression of statements that are given. And so it doesn't have to be physical evidence that is suppressed. And so obviously, we're asking for all evidence that flows from that, both from the, what I'm going to call or describe as the Berrios violation, as well as the excessive force violation. And as a third measure, what I'll advance to the court is this issue as well, which is not to look at the Berrios issue and the excessive force issue in isolation. It is the continuation of a warrantless seizure of Mr. DeHart, and that the two together in concert are a violation of the Fourth Amendment. In other words, you don't have to look at this as, okay, this is an issue of first impression with respect to an unconstitutional seizure and the exclusion based on excessive force and the exclusionary rule applied. It's not just that issue, that the court can consider the entirety of the seizure that occurs with respect to making a determination of constitution. For those reasons, with respect to the suppression issue, we ask the court to suppress all the evidence that flowed from this unlawful traffic stop. Thank you.
Thank you, Mr. Jackson. General?
Thank you, Your Honor. I'll attempt to be brief. I'm typically of the belief that technology is quickly contributing to the downfall of our society, but there are some silver linings. And one of those silver linings is in criminal prosecution. We no longer have to base facts and evidence solely on, recollection of eyewitnesses. We have video cameras that capture exactly what happened during incidents, and we're fortunate that we have that today. We have 4 separate cameras who, in one degree or another, capture exactly what occurred on February the 8th, 2024. As to defendant's motion to suppress, I guess, and we somewhat harped on the lack of specificity of the defendant's motion, but I'll start at the beginning, the traffic stop. The state has seen the video just like this court has, and respectfully submits that the officer had plenty of reasonable suspicion, actually more than enough probable cause to stop the vehicle. The vehicle weaves within its lane, touches the center line numerous times, crosses the center line numerous times, and drives down Sevierville Road straddling the double yellow line. That's a violation of 55.8.123, driving on roadways lane for traffic. That's a violation of driving on the right side of the roadway, TCA 55.8.115. That's also reasonable suspicion of a potentially impaired driver. It's not enough in and of itself to determine that someone is impaired, but it is certainly reasonable suspicion. This vehicle is not operating in the appropriate manner, and an officer has a right to conduct a brief investigatory stop to figure out why that is. And that's exactly what occurred here. So as to the traffic stop, and the court's aware of the authority as well as the state is, the state would submit clear reasonable suspicion for a traffic stop or investigatory detention. There's probable cause as to multiple traffic violations. So respectfully, if the motion to suppress is pertinent to the traffic stop, we feel the traffic stop was appropriately conducted. As to the extending of the traffic stop past the point of this initial, I'll call it the third contact. You have the 2 contacts in the roadway, but the third more substantial contact once he's pulled, that is an objective analysis by the court. Do specific articulable facts exist in that specific circumstance for the officer to be able to extend that traffic stop past the point of the initial purpose? And respectfully, really, there's a Tennessee Supreme Court case that's directly on point that was issued just last year. I believe that was the Green case that the Tennessee Supreme Court talked about that fits this scenario almost exactly. Mr. Johnson is correct that the odor of marijuana in and of itself, taken completely, that's all you have, does not create a per se probable cause to conduct a search. But that's not what Deputy Edgars testified to. She testified to the totality of the circumstances, what she had observed. 1, the defendant's operation of the motor vehicle, which the state would respectfully submit was very erratic. 2nd, her interaction with the defendant. The way she characterized his conversation, his responses, that he seemed nervous, that he was talking in an excessive manner than what she was used to under her experience as a law enforcement officer. His slight delay in getting documents, his inability to get the insurance at all until she came back the 2nd time, but his delay in getting the documents. So that is almost, in and of itself, exactly what the Green case addresses the Tennessee Supreme Court in 2024 issued. No, the odor of marijuana by itself is not a per se probable cause, but it is a very large factor that the court can consider. And what Deputy Edgars testified to is to his erratic driving, based on her experience, her evaluation of the oddities and the way that he responded to her questions, and the way he was conversing, and then the odor of marijuana. And those 3 things together do create probable cause. But really, there's actually 3 separate, honestly 4 separate and distinct reasons why she can ask the defendant to get out of the vehicle at this point in time. 1, an officer, for officer safety purposes, can ask the defendant to exit a vehicle during a traffic stop just to issue the citations. That's a perfectly reasonable ground. Second, as was clear on the video, she intended to conduct a DUI investigation. She does not have to tell the defendant that. Mr. Johnson complains that she only mentioned to him that she was going to search the vehicle. There's no law that requires that she inform him that one of the reasons she's asking him to exit the vehicle is a DUI investigation. The question is, does she have reasonable suspicion to conduct a DUI investigation? And based on the driving patterns, based on her observations of the defendant, based on the odor of marijuana, the state respectfully submits that she did have reasonable suspicion to conduct a DUI investigation. The state also disagrees with defense counsel's assertion that probable cause did not exist to search the vehicle for the odor, for the contraband, the marijuana. I've touched on that already. That's a third cause. And then she has a right in those scenarios to reasonably extend that traffic stop for officer safety purposes to get a backup officer there. If she is going to conduct a DUI investigation, if she's going to conduct a search of the vehicle, she can reasonably, within a reasonable amount of time, extend that detention in order for officer safety to get a backup officer there. So the state would submit that there are 4 separate distinct reasons why she can ask the defendant to step out of the vehicle. And she did ask him over and over and over again. And then she told him over and over and over again. And then Deputy McCowan asked him, and then Deputy McCowan told him. By my count, and this is probably conservative, 27, 28 times I either asked or directed the defendant to exit the vehicle, and he refused to do so. So respectfully, the state, we're talking about a passage of maybe 15, 17 minutes. This is not an unreasonable long detention for a traffic stop based on reasonable suspicion, and then an extended investigation into potentially impaired driving, intentionally possession of marijuana, based on these officers' specific articulable facts that she relayed on the stand. Deputy Edgars owns the fact that a week after this shooting, she told the TBI that she didn't smell marijuana until her second approach to the vehicle. That's clearly not the case, and she owns that it's not the case. She testified today that she smelled the odor of marijuana upon her the first longer interaction in the driveway. She owns that's not what she told TBI a week after this happened. And she owns that fact. That doesn't make her a liar. That makes her somebody who went through a very traumatic incident and is owning what the testimony is now. She didn't deny that's what she told TBI. She confirmed that's what she told TBI, but that's not what the facts and proof bear out, both from her testimony here today and the video that captures the event exactly. And I want to touch briefly on this excessive use of force. I respectfully just disagree. I don't think it's excessive use of force. I think Deputy Edgars and Deputy McCowan did exactly what they were trained to do, and they did it the right way. But I find Mr. Johnson in somewhat of a contradictory paradox here. On one hand, he's saying she elongated the traffic stop. On the other hand, he's saying, well, she should have de-escalated by waiting. Waiting is one of the de-escalation techniques, so she should have just waited. So he's saying it should be suppressed because she extended the traffic stop, and then he's saying it should be suppressed because she didn't wait. Likewise, he says another de-escalation is to call more officers. But then on this hand, he complains that she called Deputy McCowan for backup and she was waiting for more officers to arrive. On the other hand, he's saying she should have waited for more officers to come to de-escalate the situation. That is some armchair quarterbacking, respectfully, to Mr. Johnson. And whatever she does, she's danged if you do, she's danged if you don't. The court can evaluate the video, the court can evaluate the evidence, the court knows the law as well, probably better than the state does. The state respectfully submits that this officer acted in an objectively reasonable way based on the facts and evidence that were presented before her. That she had a reasonable suspicion and probable cause to conduct a traffic stop, that she had a reasonable suspicion to further that investigation into both impaired driving, into both the possession of marijuana, and that she acted very reasonably in her request to have Mr. DeHart exit the vehicle, in her directives and orders for him to exit the vehicle, to her attempting to physically remove him from the vehicle, and then going up the use of force, continuing to ultimately tasing him. All that said, Your Honor, respectfully, there is zero authority that says any of that, even if the court were to find that was a bad traffic stop, that she didn't have a reason to extend the search, none of that gives him immunity to pull out a gun and kill somebody. There is no authority that says he gets just blanket immunity for his actions based on an unreasonable stop, based on an unreasonable search, based on an unreasonable detention. His actions were the ones that were not reasonable. He pulled out a gun and he shot and killed somebody. And I know the court has not seen the video as often as the state has, but after those 3 initial shots, he opens that door, he stands out of his vehicle, he points that gun down at Deputy McCowan, and he shoots him point
Well,
blank.
object to that. That's not the evidence.
That is the
That
evidence.
is not
Watch
the evidence.
video.
The video's in there. I mean, we're talking about suppression. I don't know where he's talking about now. But that's not the evidence.
I'm talking about what I saw.
Well, that's not the evidence before the court.
Time out, counsel.
Back to suppression.
Back to suppression,
Yeah.
I'll be honest with you, I didn't see that, but I would look it for it.
Yeah.
So,
I've
I'm
watched
not
the video
saying
several
that-
hundred
I'm not
times.
saying that
Yeah.
It
Back
didn't
to-
happen, but that really won't impact what we're doing.
Sure. Back to suppression, Your Honor. I'll round it up by saying the officer's actions were objectively reasonable based on the proof and evidence before the court. So respectfully, as to the traffic stop, we would ask this motion to be denied. Oh, and I should have touched on, there is nothing that requires, he is not in custody, he is not in a custodial interrogation. I know that Mr. Johnson mentioned Miranda in his motion to suppress. The authority is clear that they are not required to Mirandize a defendant during an investigatory stop. So as to suppression based on Miranda, as to suppression based on the unreasonable detention, as to suppression based on lack of probable cause to search the vehicle, state respectfully submits that those just aren't here today, and that the evidence creates both reasonable suspicion and probable cause, and the officer's actions were objectively reasonable.
Is your witness here?
Since it's my motion, can I say a few things in reply?
Sure.
Uh,
Lawyer always wants to say one more thing.
Absolutely. Nothing like having the last word.
Go ahead.
Thank you, Robert. Also giving Mr. Kurtz time to check. Very briefly, let me touch on this issue of, Deputy Edgars not having to tell Mr. DeHart why she wants an exit vehicle. And respectfully, that misses the point. It just misses the point. It also, all these things about trying to say one thing and then say another, and those being inconsistent, miss the point too, with respect to legal arguments. I'm going to hit all that, but I'll hit this one. It explains why Mr. DeHart doesn't exit the vehicle. Because she says, I've got probable cause to search, and his response is, I don't consent to the search. I don't consent to the search. She never posed the question to him, I just want you to exit the vehicle because we're going to do some field sobrieties. That's the issue. She clearly is indicating at that point in time she's got probable cause to search the vehicle. And that, for these reasons, Your Honor, we ask the court to suppress the evidence that we have moved the court to suppress.
I think your doctor's here. Do you, thoughts about something? Yes. Tell me what the doctor's here for, though.
She is, as the court's aware, at a preliminary hearing, we're entitled to present evidence to rebut probable cause. Mr. DeHart is charged with, via the warrants, before the court in General Sessions Court, he's charged with first-degree murder and attempted first-degree murder and being a felon in possession of a firearm. And so we are calling the medical examiner to submit rebuttal evidence as to probable cause.
Okay. That is fine. Ready?
All right.
You ready?
I'm ready. I'm ready.
Okay.
All right.
You solemnly swear to affirm that the truth
I do.
And I don't know if Mr. Johnson plans to qualify her, but we'll stipulate she's an expert in the field of forensic pathology and all that good stuff. We've dealt with Dr. Lucy plenty. We have no qualms as to her expertise.
Okay.
All right. Appreciate that. Dr. Malusnik, please state and spell your name for the record.
My first name is Darinka, spelled Barinka, and my last name is Milusnik-Polchan, spelled Milusnikpolchan.
And Dr. Malusnik, what's your current position?
I'm the chief medical examiner for Knox, Anderson, and Blount counties, since November 1st, actually recently. And I'm also the senior pathologist supervisor of the autopsy division of the Division Forensic Center in Knoxville.
And in that capacity, you conduct autopsies.
Yes,
And you also supervise other physicians who are forensic pathologists who conduct autopsies.
yes,
And since we've stipulated as to your credentials, did you have an opportunity to conduct the autopsy of Deputy Gregory Allen McCallum?
yes.
Approach the witness, Your Honor.
Yes, sir.
And Judge, I'd like to mark this as the next exhibit. It's the autopsy report. Wait for the record, it's Exhibit 8. Dr. Malusnik, I'm going to hand you the autopsy report.
And if you could just flip through that and confirm that is the report you prepared in this matter concerning Deputy McCallum.
Yes, this appears to be an accurate copy of the autopsy report on Deputy McCollum, and it has 6 pages plus a toxicology report, which becomes a part of the autopsy report.
All right. And that's Exhibit 8, correct, Doctor?
Yes,
Now, in conducting the autopsy of Deputy McCallum, were there 2 gunshot entry wounds
yes.
in the body? Where were those gunshot entry wounds?
One gunshot wound of entrance was on the, what we call anterolateral right chest, and the second gunshot wound of entrance was on the lower left abdomen, kind of anterolateral to the left side.
Just approach the witness just to help demonstrate a little bit. Sure. Dr. Malusnik, using me as your dummy here, can you point to where the 2 entry wounds were on my body?
So one entry wound was lateral from the areola on the chest, and the second one low down in the abdomen, right about the pubic area.
All right. And were there exit wounds on the body?
No,
Were there injuries on the body that would indicate to you where the projectiles ended up in the body?
yes,
And were you able to find projectiles in the body?
that's correct.
All right, so I'm going to turn my back to you. And Judge, I'll apologize, my back is to you. But if you could indicate just on my back where the projectiles came to rest in the body.
One of the projectiles that was well preserved was approximately recovered from this particular area of the body, and the second one was slightly higher up and lateral on the left back, so both were on the left back.
All right, thank you, doctor. And on autopsy, did you discover that one of the projectiles had hit the spinal column?
That's correct.
And did that alter the trajectory of that projectile in the body?
It altered it slightly, it deformed the projectile, the bullet, and altered it slightly, so instead of going through the spinal column, it just continues slightly upward with a slight angle, just like anything that hits a wall would kind of bounce with a slight angle.
So the entry wound that was in the, for lack of a better word, the upper chest area, do you have an opinion about whether or not Deputy McCallum was standing or he was on the ground concerning the entry wound in the upper, in the chest area of the body?
So just looking at the body itself, it's hard to discern really or conclude the position. However, I did have a chance to review all the videos, body cam videos, because it's part of the medical legal death investigation. And my conclusions is that he was standing when the chest, anterolateral right chest was hit.
In the first entry.
That's correct.
And so the second entry wound that you said was in the lower abdominal area. Is it correct that from from the anatomic findings, you're not able to ascertain specifically if the body was standing or on the ground. Is that right? Just the anatomic findings, just looking at the body.
Right, just the body itself never really tells us the full or whole story. That's why we always rely on the scene investigation to come to conclusions or answers to questions like this one.
All right. But from looking at the videos, just looking at the body, you can't ascertain whether or not, in other words, Deputy McCowan was standing when he was shot in the abdomen, correct?
I'm sorry, could you say?
Just looking at the body, just the anatomic findings, just doing the autopsy, you cannot ascertain whether or not Deputy McCowan was shot in the abdomen while he was standing, correct?
Well, if I didn't have any information whatsoever, I could not answer that question.
Right. And so the answer to my question is correct. You can't ascertain just from looking at the body, correct?
Just looking at the body, that's why we never just look at the body.
Right. Now, you looked at the videos too, right?
That's correct.
And those videos were provided to the Forensic Center by the Blount County Sheriff's Office, is that right? Or to the TBI?
I believe the investigating agency, which is TBI.
The TBI. And those are part of what you relied on in formulating your medical opinion here, is that right?
Well, some of the medical opinions expressed in court that the anatomical question as far as the cause of that would remain the same regardless of the videos. But yes, in order to be able to answer other forensic questions, yes, I did rely on those videos.
You looked at the videos. And from looking at the videos, you saw that there are 3 quick shots in succession by Mr. DeHart while he's being tased. Did you see that, Doctor?
I didn't count them. There were multiple, but yeah, I would actually prefer to kind of watch the video at the slow motion again, and probably I will before the trial, but it seems to be pretty accurate.
All right, that's accurate. And to be fair, you watched the video just on Friday of last week, correct?
That was well, I watched the video a couple of times when I was signing out the case, and then we had some questions, conversation over the phone, and I did watch the video again in order to be able to answer that particular question that counsel had.
Yeah, and when you said we had a conversation on the phone, you and I spoke on the phone on Friday, is that correct?
That's correct.
All right. And when we spoke on the phone on Friday, I asked you that, are you able to pinpoint any particular shot on the video to either one of the entry wounds? Do you recall me asking you that?
I believe that the question was whether, when you mentioned like 3 shots, I believe the question was whether I could discern which one of those shots could have entered the body, and I said no. I couldn't really discern which one of those 3 shots would have been the one that entered the chest. I believe that was my understanding of the question.
Right, and not just those 3 shots, but I think I asked you, once the tasing stops, there's a final shot that Mr. DeHart fires. Do you recall me asking you that?
I don't recall all the details. I recall that when the counsel asked me the question, it was a succession of multiple shots. That was my understanding, I'm sorry, which one of those shots was the one that entered the body, and I couldn't really answer that question because they all happened so fast in succession.
All right, so you can't recall what you told me now when you talked on the phone?
No, that's not what I said.
Okay, I'm just trying to understand.
No, what I said, I could not really answer the question which shot was exactly the one that shot the body when he was standing up. I did answer your question as to how the shot to the abdomen would have happened, and my question to that my answer.
Your answer to that question.
I'm sorry. Yes, my answer to that question was the only way for that shot to be sustained is for the victim to be on the ground to expose the kind of underbelly, the lower abdomen.
Right, and that's why I asked you earlier. From watching the videos, you now are able to ascertain what placement the body was when that second shot went in, correct? It was likely on the ground.
That's exactly. So the quick succession, I couldn't really tell which one was the one that exactly entered the chest, but I could answer with certainty that the one entering the abdomen is when Deputy McCowan is on the ground.
Right, and so now let me get to the question I just asked you a moment ago, all right? of all the shots on all the videos, to include this final shot at the end. You recall watching that?
Yes.
Okay. You are unable to pinpoint any particular shot on the video to the entry wound in the abdomen, correct?
I don't recall how many shots were fired when he was already on the ground. I'm sorry, I just didn't go back and count the shots.
Right, and I'm gonna ask the question again. So however many shots were fired while he was on the ground, your opinion here today is clear. The entry wound at the abdomen, it's your medical opinion occurred while Deputy McGowan was on the ground, correct?
Yes, he had to be on the ground for that shot to be sustained, but I don't recall how many shots were fired when he was already on the ground.
Yeah, and so then that leads to this next question. However many shots were fired while he was on the ground, you're unable to pinpoint any particular shot fired while he was on the ground to that entry wound, correct?
Not until I watched the video again at the slow motion so I could really count the shots to answer this particular question.
Okay. And when you watched the video on Friday and we spoke, you didn't say I need to watch it again in slow-mo, did you?
All right.
I mean,
If you
did I
want to
have
ask
to?
her a question about her findings or what happened, that's fine. Asking her about a conversation he had with her on Friday, I think is inappropriate. I think it's fair to ask her questions about what her findings are and what her opinion of the evidence is.
Well, actually, that was the old rule. I think you can impeach your own witness now.
Yes.
Not that you're being impeached, he's just testing your memory. Don't worry about that. Do you remember what you said to him on the phone?
Yeah, I remember exactly what we had a conversation. The main question was, at which point is he shot, or which position the body was when he was shot in the chest, and in which position was the body in when he was shot in the abdomen. I said he's standing when shot in the chest, and he's on the ground when shot in the abdomen. And then that was pretty much the main part of our conversation. Now, I was not asked how many shots were fired and which one exactly, 1, 2, 3, 4, or 5, or how many ever were there to kind of point out. I said all I know is that he's standing, he's shot, he goes down, he's on the ground, and then she's shot. But
And what you're telling me now is you don't know now which one of those shots was the one that was fired and he got hit in the lower abdomen while he was laying.
right, because right now I don't recall how many shots were fired when he was already down. I have to watch the video to answer that particular question.
Okay, fair enough. I think she's answered your question.
I think she has.
I'm ruling she answered your question.
All right. Thank you, Judge. And you did watch the video on Friday, correct?
Yeah, I watched the body cam and then cruiser videos, yes. If I may say just one more thing, I wish I had been asked, to kind of go shot by shot and answer that particular question, but that was not the question.
I'm sure you'll get the chance.
I will, thank you.
I have nothing further, Judge, at this time.
Okay.
Dr. Malusnik, would it assist you to watch the video, the portion of the video where the shooting happens again here in the courtroom today? I'm sorry. Hello.
Yes, good afternoon. As a matter of fact, if that's a possibility, I wouldn't really mind. Can we have it at a slower motion?
We can cue it up. I'm not sure if we can play it in slow motion, but we can certainly play, and this would be.
Or maybe at least part of a fragment?
It is exhibit.
No, 6. I think the 5 convictions were first, and then it was 6.
I assume we can run it to the point where
If that's okay with Your Honor.
Please do.
Okay. I'm not the most proficient in the office with technology, so he will have to do that part.
Yeah, there were 2 body cam and 2 dash cams, and this is one of the dash cams that I watched. And I believe this is one that might show the best his movements in the position.
6:44 Right. Traffic. Anyone else think?
Can you pause it for a second, John? For some reason, it went black on the screen during the actual shooting.
Black?
Yes.
It looks like
Oh, sorry.
you're not going to be able to do that in the system without shutting it down and starting it all over again. I think you can try it again, but.
Try one more time.
That last shot that we saw there, Dr. Malusnik, when the door is open and the arm comes out and points down at the prone victim on the ground, is that the shot that you believe to be the abdominal shot?
I don't think he was prone. I think he was more kind of a spine at an angle.
Okay, so you believe that to be the shot that entered the abdomen?
It seems from the direction of the fire that could be the one, yes.
And that is because in your medical opinion, that the direction of the movement of the bullets in the body, combined with what we're seeing on the video, leads you to that conclusion, is that right?
That's correct.
So it is the anatomical findings in conjunction with what we're seeing on the video.
That's correct.
Do you have a medical opinion, Dr. Malusnik, on whether that the other shot, the chest shot, the right chest shot, would that shot have killed him alone?
If medical intervention was not applied immediately, yes. But even with that, it was a very serious shot. Both lungs were struck, diaphragm and spleen, so those organs would bleed, and without really intensive immediate help, that would have been a deadly shot eventually.
And then the second shot that entered the abdomen that we saw there on the video, where the car stops, the door opens, the shot is fired at the body on the ground. What about that shot? Would it have killed him alone?
Absolutely. Actually, that's the shot that was the most serious wound because it hit the aorta.
That's all we have at this time, Doctor. Thank you.
Just turn the lights back on. You don't.
Yeah,
you see the
I
video?
actually, I want to pick up one more time.
Okay,
if
so
you don't
let's
mind.
take off.
And General Desmond can be my IT support. If you can go back, you don't have to watch the whole thing, but back sort of before, right before the shots begin. General. Pause right there, please. Dr. Malusnik, on Exhibit 6, we're paused at, for the record, 20 minutes, 23 seconds, or 20, 34 and 4 seconds. Is that correct?
Yes.
On the top right of the video?
Yeah.
And the frame that we're frozen on right now,
I think it's 2023.
oh, I'm sorry, 2023-04. 2023-04. And with developmental employees. And so, at that point, on that frame, you can see Deputy Edgars toward the center of the video, and she is still standing but is falling backward. Is that accurate, Doctor?
Yes,
And in that frame, Deputy McCowan is fully on the ground at that point, correct?
that's correct.
And at this part of the video, there have been 3 shots in rapid succession fired, correct?
Right, that's the one that I said I couldn't tell whether number 1, 2, or 3 shot him.
Right. And that's the one where you can't tell, just from looking at the video up to that point. Obviously, there were 3 shots in rapid succession, and some of them occurred after he was already on the ground, correct?
Yes.
And if you could play from there, General. Pause, please. At that point, the shots that were fired, were you able to tell in which direction they went at all?
Actually,
Just from the video?
no, I couldn't from the
No,
video.
you can't from the video. You do know that Deputy Edgars continues her fall as we go through the next frames of the video, correct?
Yes,
All right, and for the record, we're paused, and I'll get it correct this time. 2037, or 20, thank you, 2023-07. That transcript will be a mess because I can't say the numbers correct. 2023-07 is this particular frame that we're paused on right now. General, if you could go ahead and move forward. Pause, please. What we watched from the last frame to this frame, you don't see the body of Deputy McGowan move at all during those next shots, do you?
which next shots?
Well, the shots that occurred between when we had it paused before and when we have it paused now, the body did not move at all, did it? You want to watch it again?
Yes, actually, because I believe the question is, Your Honor, whether there's 2 shots in the middle? Is that what you're asking?
Well, there were 2 shots in the middle, then there's a shot kind of at the end.
Right.
And what I'm asking is, after these 3 first shots in succession, okay, the shots that occur after those 3, I want you to watch Deputy McGowan on the ground, okay? And then I'll ask you some questions.
Okay.
Please go forward. You'll pause now, Jim. Other than, did you see where Deputy McGowan's arm kind of slowly went down?
Yes.
Okay. Other than that slow movement of his arm going down, did you see the body move at all?
No, and I wouldn't really expect it because when his spine was hit, that would cause trauma to the spinal cord, and I wouldn't expect him actually to move his lower body at all.
Oh, okay. So, and the spinal cord was hit not from the shot that went into his chest, correct?
That's correct, yes.
The spinal cord is hit from the shot that went into the lower abdomen, correct?
Yes, the one that hit the aorta.
Yeah. It went into the lower abdomen, I think you testified, it then hit the spine, and it changed its trajectory a bit.
It's slightly ricocheted
Right.
upward, yes.
And so, you would not
Actually,
expect,
back to the kind of left side.
you would not expect the lower body to move after that shot had gone in, correct?
Yes, I think that would be kind of classic paralysis from just a traumatic event in the, kind of on top or at the spine at the low thoracic level.
No further questions, Judge?
Nothing further from Dr. Miller.
All right, then, Mr. Johnson, I think that was your proof.
That's our proof this is probable cause, yes, Your Honor.
Okay.
That's what
I don't
it got
eat
over.
either, so.
Well, I had a big breakfast.
yours, Ryan?
Oh, I thought that was mine, I'm sorry. Yeah, I should have,
This is just what it brought with it.
right.
You know what the law is? I feel like, but I've got a so-called witness in sections.
has the predominant factor that the court is to consider is flight risk. After it was amended, the court also has to consider community dangerousness as well. And what is clear, though, is that even in a case where there are first-degree murder allegations, the defendant is entitled to bail. And the Tennessee Constitution says, except when the proof is evident or the presumption great, even in a capital case, the defendant is entitled to bail. And in this case, Mr. DeHart is charged with first-degree murder, attempted first-degree murder, and being a felon in possession of a firearm. And on the bail issue, Your Honor, he has been held without bail being set. He's been held without bail, with any mechanism to make bail, without a monetary bond being set for him to make bail. And we asked the court to make those findings and to set a mechanism for bail in Mr. DeHart's case. The record in this case is clear, and we pointed this out in our motion. Mr. DeHart is a lifelong resident of Blount County. His criminal history, as the court is aware, is largely old, his felony convictions, and roughly 20 years old, if I recall correctly. He's got some more recent ones, but I believe those are misdemeanor offenses, if I recall. And even if they're not misdemeanors, they're several years in the past. And there's not been an issue. Mr. Hart has significant ties to the community. He has significant family in the community. And so we would ask the court to at least set a mechanism to make bail here. I did not attach these filings to the motion that I sent to Your Honor in Sessions Court, the bail motion. The motion that we filed in criminal court, we attached examples in other cases. The state's already seen these. Your Honor, I'm going to put in the record here, and I'd like to show to the court, in other cases, to include first-degree murder cases in Tennessee, to include death penalty cases in Tennessee, to include cases where there have been multiple homicides, courts have set monetary bonds. And in Blount County, I believe this is the last death penalty case in Blount County, State versus Arthur Copeland, the court set a monetary bond of $400,000. And I have that order. In a case in Knox County that I tried twice, State versus George Giovanni Thomas, there was a monetary bond set at $2 million, and in that case there were multiple homicides involved. In a death penalty case that Mr. Kurtz and I had in Roane County just in the past couple of years that involved multiple homicides, State versus Michael Anthony Gray, the court set a total monetary bond at $500,000. In State versus Art Schutte in Campbell County, that was a second-degree murder case, the court in effect allowed a signature bond of $50,000. And Daquan Dodd in Sevier County, the court allowed a $500,000 bond, but $50,000 by a bonding company and another $450,000 by signatures from family members. I just provide these as examples to the court. These are public pleadings, public filings. Coach, Your Honor? Sure. And I'd just like to make those collectively the next exhibit to this hearing. By way of example, and the point that I make is that, as the court's aware, you don't get a bond, you're not held without bond, even in a capital case. And the bond may be so high that someone can't effectively make it. And that's another issue. But we are asking the court here today to set a mechanism for Mr. DeHart to make bail, even if that is monetary bond, for the reasons that we have briefed before the court and that are in our filings before the court. And that was the bail issue, Judge, and do you wish to hear any argument about probable cause?
I thought we had that.
Oh, we had about suppression.
Okay.
I didn't know if you wanted to hear from the parties about probable cause or not.
I don't think I probably need that. On bail issue, do you have any, if I were to put a monetary bond up there, bail, do you have any conditions that you would offer?
Your Honor, as the statute says, the court is to place any conditions that the court believes is appropriate to accomplish the goals of the statute, whether it is non-appearance or the court, we maintain that the court has to use the prior statute, not the current statute, but even if the court uses the current statute, I think relatively the same conditions could apply. The court could put Mr. DeHart on house arrest. He has lost his home now since he has been in custody, but he has a number of family members that are in the community that would be willing, could be willing to let him live with them. The court could put house arrest, the court could put GPS monitoring on him, and there are measures less restrictive than full confinement that the court could place in addition to a monetary bond.
And my other question is, I know you talked about the application of the amended bond statute. You have a case that says I shouldn't use the bail statute that's in effect at the time the bail request is made?
No, actually,
You're actually arguing the opposite. I should use it at the time the crime was committed.
I'm making in essence, I actually looked at this and I could find no authority precisely on this point.
Okay.
And for the record, what I would state is that ex post facto applies to punishment, obviously, as a matter of constitutional law. We're not dealing with punishment, but the U.S. Supreme Court is clear under Stack v. Boyle that the denial of bail is a form of pretrial punishment. And so my argument to Your Honor is apply the bail statute in effect at the time of the commission of the offense, of the alleged offense, avoids the ex post facto issue, that the court has to use the statute in effect at the time of the alleged offense to avoid the ex post facto issue. That's our argument to the court.
One other question, because we find ourselves in kind of unfamiliar territory here, this being the second preliminary hearing, what consideration, if any, should the court take that the grand jury's already heard this case and indicted you on it?
Your Honor, the grand jury certainly has heard the case. The grand jury has indicted Mr. DeHart. Those cases where a new preliminary hearing has been ordered, I believe the authority is that the court is to consider the evidence as if the indictment did not occur. And if the court's asking me specifically about the issue of bail and the indictment, I respectfully submit to the court that that is a nullity as well. And I would also note that the grand jury indictment in this case, we don't know precisely what evidence was presented. And ostensibly it was presented following the presentation of evidence at the prior preliminary hearing, which Judge Harrington has ruled was constitutionally deficient. And so I think this court has to consider this hearing in isolation.
Okay. And following up on that, I assume if I do find probable cause, you want another grand jury to look at this?
Yes, Your Honor.
Okay.
We think that there has to be another grand jury presentation of evidence in this case. And I would also note that the prior grand jury, the alleged aggravating circumstances that the state filed with its notice, those were not presented to the prior grand jury. And I just want to note for the record that we believe that a grand jury has to find those specifically. That is an issue the U.S. Supreme Court has not dealt with directly. On the federal level, federal courts, after a Prende versus New Jersey, and after a decision in Arizona, they have, on the federal death penalty level, they charged the aggravators in the indictment. Now, I know that the Tennessee Supreme Court has its own interpretation of the Prende and has said that that's not necessary. And I just wanted to note that the U.S. Supreme Court's not decided that issue yet, and I want to put on the record, given the nature of this case, we maintain that a new grand jury has to review this case, and that for it to be a capital case, those aggravating factors also have to be presented to the grand jury.
Thank you, Mr. Johnson.
Thank you.
Jim?
Thank you, Your Honor. And I respect Mr. Johnson's position on this last point. The state intends to continue to do what the Tennessee Supreme Court, the United States Supreme Court tell it to do, and we probably won't do otherwise until we're instructed to do so. Your Honor, Mr. DeHart is in a different situation than the vast majority of individuals who come before a judge in the criminal justice system. He is not, by the Constitution of the state of Tennessee, entitled to bond if Your Honor finds that the proof is evident or the presumption is great based on what you have heard before you today. It's very clear, Article 1, Section 15, all prisoners shall be bailable by sufficient sureties unless for capital offenses, which I don't think there's any argument that this is not a capital offense for which the death penalty a notice has been filed, when the proof is evident or the presumption great. Now, whether the proof is evident or the presumption is great is a determination for Your Honor. The state's position is based on the fact that the entire interaction from traffic stop to shooting was recorded on body camera. The state respectfully submits that the proof is evident and the presumption is great, and that Mr. DeHart, unlike your typical criminal defendant, is not entitled to a bond. Now, the court certainly has discretion to grant him a bond if the court finds it prudent to do so, but that he is not entitled to a bond. He does not have a constitutional right to a bond under Article 1, Section 15, if the court determines that the proof is evident and the presumption is great. If the court does determine to set a monetary bond because it finds that the proof is not evident or the presumption great, well, then we have to look at the bond factors and the proof before the court. Respectfully to Mr. Johnson, his filing is not proof. He has put no proof on today as to his employment history, as to his family history, as to his community ties, as to any of that. This court has received zero proof regarding those factors, and I think the court should consider that if it were determined to set a monetary bond. That fact, his filing, does not constitute proof. The state would, to the contrary, submit that there are factors that it has put proof on before this court that indicate that any monetary bond should be incredibly substantial. Specifically, there are three factors that the state feels are appropriately considered by the court under 4011-118. Under 4011-118 B5, the defendant's prior criminal record, record of appearance at court proceedings, record of flight to avoid prosecution, or failure to appear at a court proceeding. The court respectfully has proof of 5 prior criminal convictions, 4 of which the state would submit are violent criminal convictions: a felony aggravated assault, a felony reckless endangerment with a deadly weapon, a domestic assault, and I guess felon in possession of a firearm, it can be argued is not a violent conviction, but certainly 3 of those the state would submit would qualify as violent convictions, in addition to a criminal violation of an order of protection, which the state would point out is disregarding a court order. That is what he was convicted of, a violation of an order of the court not to contact somebody, or not, whatever the conditions of that order of protection were, they were violated, and he is convicted of that. And also, though maybe the proof isn't as drawn out as it would be a trial, the court also has proof that he fled the scene of this shooting in an automobile. After the shooting, the Lexus in which he was control of fled the scene and actually struck Deputy McCown's foot as he was driving by. So I think he can consider that. Additionally, under 4011-118 B6, the nature of the offense and the apparent probability of conviction and the likely sentence, this is obviously going to be up to interpretation. I'm sure defense counsel does not have the same interpretation as the state. But if he is convicted as charged, a minimum, he is looking at life in prison. That is, if he is convicted as he is currently indicted, that is the minimum sentence he could potentially receive. He could also potentially receive the death penalty. And I believe that that heavy sentence should be considered by the court when determining whether or not, if the defendant were to make bail, whether or not he might flee to avoid the repercussions of the criminal offenses for which he's charged. And then likewise, as the state pointed out, we don't believe that there's been any proof regarding his employment status, his financial condition, his ties to the community, his family ties, or anything of that nature. So we respectfully submit to the court that that should not be considered. Obviously, I don't think it will come as a surprise to Your Honor that the state is of the position that he should be held without bond. He is not entitled to a bond. This is the specific instance that the Constitution says he's not entitled to a bond. This is the one and only criminal prosecutable scenario where he is not entitled to a bond. And the state respectfully submits there's a reason for that. And that's that he is charged with the most heinous and the most serious criminal offenses that they are. If Your Honor does choose to set a monetary bond, which the state agrees is in your discretion, I hesitate to think of a number that I think will be high enough. Many millions of dollars that I think, because as the elected district attorney for Blount County, I always draw emphasis on the statute as to the consideration of the safety of the public, the safety of the community. Mr. DeHart has proven that he will commit violent crimes, both through his criminal history and the most violent of crimes, based on the proof that is before Your Honor today. And the state would just respectfully but strongly urge, if the court decides to set a monetary bond, to certainly consider the safety of the public and the safety of the community from an individual who has a proven track record of committing criminal violent acts. So respectfully, we'd ask that bond be denied, but if monetary bond were to be set, that it be set in a manner that reflects the seriousness of the offense and the violent criminal actions of the defendant, both in his past criminal history and based on the proof before the court today.
Can I say something? Of course. Thank you, Your Honor. As to proof before the court and my filing being evidence, respectfully, there's a bail bond questionnaire that is already in the record in this case that was filled out by Mr. DeHart on February 13th, 2024 at 4:16 p.m. I quote it and I reference it in my filing. That's already in the record of this case. And it said that he had lived at his current address for 10 plus years. He had family in Blount County. He was not currently released on bond. He had never failed to appear in court. That information and the other information that was already on the record, his information is before the court. As far as whether or not this is a capital case, I will note that in General Sessions Court, a case cannot be capital because there's no mechanism of the Rules of Criminal Procedure to file a notice of intent to seek the death penalty in General Sessions Court. And so as a fundamental matter, I would say that the capital case constitutional issues, and there's a statute on that as well, that just mirrors what the state constitution says, those strictures only apply when the court's considering the case or considering bail after that notice of intent is filed. Even if the court can consider that, certainly under the bail statute and under the Constitution, the court has to consider the relative strength of the state's proof. And I'll respectfully submit to the court that even if the court finds there's enough here today for probable cause, that's different than the proof evident or the presumption great enough that no mechanism for bail, no monetary bond or other mechanism should be set at all. There's a reason why we call Dr. Malusnik to the stand. And the evidence before the court is that these shootings occurred both in the middle of while being tased and immediately after. And the testimony of Deputy Edgars is that, from her personal experience of being tased, the after effect is disoriented. And so the elements, as the court's well aware, of first-degree murder have the elements of specific intent and premeditation. And the court knows the definition of premeditation, the exercise of reflection and judgment. It can be formed in an instant, but it has to be the exercise of cool reflection and judgment. And then, of course, specific intent is a mental state where the defendant intends to achieve a result beyond merely prescribing the performed act. And of course, the court's aware of the more detailed definitions about those as well. And so here, I respectfully submit to the court, even if the court finds there's minimal probable cause as to those elements, that's a different analysis on determining that the proof is evident with a presumption great and that no mechanism prevailed should be set. For those reasons, we ask the court to set some mechanism prevail for Mr. DeHart.
All right, well, gentlemen, let me turn to the motion to suppress and probable cause hearing first. In terms of the facts of this case, after listening to the testimony of Deputy Edgars and the videos that were put into evidence, I make these findings. First of all, watching the video, it shows that the defendant's tires initially were touching the yellow line back and forth. It then shows the defendant touching and crossing the center line multiple times to the point that it stayed on the wrong side of the road for a period of time. Once the blue lights were initiated, the defendant did pull over, did pull into the driveway, ultimately pursuant to the deputy's instructions, where she informed him that he was, our memory was, all over the road. She obtained the defendant's license, went back to the patrol car, called Deputy McCowan, and it was at that point that she informed him that the car smelled like weed and that she thought this was a DUI case. I put more credibility, really. I wanted to hear what Deputy Edgars said, but what was happening in real time, that's where I place a lot of credibility. There wasn't any reason to do anything other than to explain what was happening in real time. That's what she said. She asked for backup, which I find to be a reasonable request just for officer safety if you're going to initiate a DUI stop. It's true that the dispatch confirmed that there were no issues with the defendant's driver's license. And she did go back to the defendant's vehicle and informed him that she wanted, after talking to him, that she wanted him to step out of the vehicle because she did smell weed. And at that point, the defendant refused Deputy Edgars' instructions. Adamant. And then it appears for the next 5 or 6 minutes, Deputy Edgars argued with the defendant, asked him to exit multiple times. He continued to refuse. Deputy McGowan arrived. I think it's undisputed. That was about 10 minutes after she stopped talking to dispatch and instructed the defendant again, get out of his vehicle, and that's when he told him he would not allow them to search his vehicle. He even rolled up to his driver's side window. Deputy Edgars opened the door to physically remove him from the vehicle, which he resisted. Deputy Edgars attempted to really unbuckle his seatbelt. He grabbed her, pushed her arms away, and it was at that point that Deputy McCowan tased the defendant, and which we had found out had zero impact the first time. So order instructed to get out of the vehicle, I lost count. That's how I framed it. Deputy McCowan used his taser, and Deputy Edgars attempted again to take the seatbelt off, and they kept telling the defendant each time he would be tased again if he did not get out. He continued to refuse, and at that point, the door was slammed shut. Deputy McCowan used his taser for the third impactful time, and that's when the defendant pulled out his handgun, fired multiple shots at the deputies, striking both Deputy Edgars and Deputy McCowan. And then one final shot at Deputy McCowan, who was laying on the ground. He then drives off in his vehicle. Deputy Edgars fires 3 shots as he was leaving. In terms of probable cause and motion to suppress, the rules do require the defendant to articulate exactly what they're asking the court to suppress. The motion did not do that, but in court, Mr. Johnson did articulate that ultimately what he wants the court to suppress is the actual shooting of Deputy McGowan. So that's what's at stake here. With regard to the stop, it is true that law enforcement may initiate a lawful traffic stop when the officer has reasonable suspicion to believe a traffic offense has occurred. And that stop can become an investigatory stop without the warrant if that officer articulates certain facts that reasonably warrant a Fourth Amendment intrusion. So in this case, the proof shows that Deputy Edgars did have reasonable suspicion to perform that traffic stop just based on the defendant's crossing that yellow center line on more than one occasion. In addition to that, then we had, after the stop, the smell of marijuana coming from the vehicle, which again would support her suspicion that this was a potential DUI stop. And in addition to those 2 things, it's been talked about some, but there's also the defendant's own behavior during the stop that I find to be a significant factor. He was nervous. He was way too chatty. And I do find, based on all those 3 factors, that under the totality of the circumstances, he should have gotten out of that car when she asked him to get out, and that only increased, probable cause only increased based on his own behavior, which was to object, obfuscate, do anything he could, but he wasn't going to get out of that car. And I think that's what's important to note. This stop got out of control because the defendant refused to comply with the deputy's request to exit the vehicle. So here's the situation. Law enforcement has requested a citizen to exit their vehicle. The citizen has refused again and again to numerous requests to do that. So what is law enforcement supposed to do? Here, the deputy took the next step, which was to physically attempt to remove the defendant from his vehicle. He refused. He even physically resisted. That led to Officer McGowan's next step, which was to use the tase. After again informing him that would happen if he did get out of the vehicle. I do not find there was excessive force here in this case. And it was justified because of the defendant's conduct, continuous refusals to comply with the deputy's request. But I do find there was probable cause in this case. And I'm not suppressing what really is the did after his initial seizure, if you want to look at it that way. Even if this investigatory stop was invalid, even if there was no probable cause, there's absolutely no justification for a citizen to refuse to comply with a request by law enforcement to step out of the vehicle. And everything that happened after that point is the result of the defendant's own actions in this case. If a citizen believes he's been unlawfully stopped and searched, his remedy is with his lawyers right here to come in, file a motion to suppress whatever it is for an illegal stop. It is not to take the law in your own hands and shoot and kill the officer because you don't like that. So, again, I wouldn't exclude this evidence even if I found it was an illegal stop, because I find that it was a completely separate and independent crime here. So the motion to suppress is done. Turning to bail. I am taking notice that the state has filed an intent to seek the imposition of the death penalty in this case. And I look at that because the statute provides that all defendants may apply for bail, except for capital offenses where the proof is evident and the presumption is great. I've heard the eyewitness testimony of the deputy. I viewed this episode myself with all of you. And I've considered, I did see, by the way, the last shot, where he intentionally leaned over and shot the deputy. I saw that. So I'll consider the fact that after he did that, he drove off. And then he remained in hiding for 5 days. So I do find the proof is evident in this case, video evidence, and the presumption is great in this particular case as what the ultimate penalty may be in this case. And so at this point, I do not bail. That'll be my decision. All right.
Your Honor, just,
Oh, and I didn't say this, I do agree here, this will be bound over to the grand jury again.
thank you, Your Honor.
Yes, sir.
And Your Honor, inherent in the court's ruling, but just for the record, I know the court said that it found probable cause for the stop. And given what the court said, just want to make it clear, the court has found probable cause for the charged offenses in the warrants. Thank you, Judge. That was inherent in what you said. I just wanted to make it clear.
I don't want you to ask